Sorry. Just a moment.
1 second. Pronouncement of judgment, list number 1, C number 1, Shri Narayan Swami VK, Shri Abhishek Madipati.
We are of the opinion that the prayers as sought for in the writ petition cannot be granted. Writ petitions therefore fail. However, we also feel it appropriate to issue directions to the KEA and the state government for future guidance. State government as well as the Director of Medical Education are also writ petitions are disposed of, KEA is directed to see that, oh, this, they've left it out. That appropriate directions with regard to decategorization are provided in the brochure itself. The state government as well as the Director of Medical Education are also directed to look into the said issues as stated above and to issue necessary instructions while the brochures are being prepared by the KEA in future. Please ask for direction to be incorporated. Let that be incorporated and only then it should be.
Yes.
And tell her to show it to us also. Please come. I didn't ask you to delete that. The portion with the direction to the KEA should be there. Please include it and show it to me now. Sir. Immediately. Yes.
Right.
After that, it will be circulated and uploaded. Today itself.
Mentioning if any, list number 1, page number 1, number 2 and 3. Page number 2, number 4 to 6. Page number 3, number 7 and 8. Page number 4, number 9. Page number 12, number 10.
You are for the
Serial number 10 for the respondents, my lords.
1990 preliminary notification, Vishwesharaya layer. Yes. At the request of the learning council. Just after 2 weeks.
25th,
Obliged.
25 to. Page number 13, number 11 to 15.
11. You are for the at the request of the learning council for the appellant. Just after 2 weeks.
27.
Is interlocutory application.
15, I represent the respondent. I oppose any adjournment. It's a suit for recovery of money.
Please be here. Please be here. We'll consider when it is taken up.
Page number 14, number 16 to 19. Page number 15, number 20 to 22. Page number 16, 23 to 25. Page number 17, number 26 and 27. Page number 18, number 28. Page number 19, number 29 to 32. Page number 20, number 33. Page number 21, number 34 and 35.
21, serial number 34. A tax matter, because the year is 2022, but as per the sitting list, all division bench tax matters are to go before Court Hall 7.
List according to roster.
I've informed counsel for the appellant as well. Great.
Page number 22, number 35. Page number 23, number 36 to 37.
It is listed for final disposal today. What is the matter about? Sorry?
3 days when I noted it for final disposal. Alerts it may be taken up in the final year.
There must be some reason for it to be listed for final disposal. Have you informed the other side?
State is that.
No, there are other counsel as well. Please make submissions only after informing the other side. We don't know whether there's any. Please inform the other side and then tell the court officer, not without that. Yes.
Page number 24, number 38 to 40. Page number 27, number 41. List number 2 for orders, number 1. Sri Sirajuddin Ahmad.
Respondents, 10 minutes.
The deportation matter.
Please.
Objections filed?
Lord, the state has preferred an appeal in criminal appeal 2002 of 24.
Recorded last time.
Please, my lord, the notice was supposed to be served in the detention center. However, he has refused it, my lord.
This you need to file objections. Explaining why you don't want to deport him.
The reason is this, please, my lord, please, we'll file. Please, we'll file.
From the AST last.
Please, sorry,
That should be there on the record.
please.
Both of you.
To enable them to place their objections is the order. Please
We'll-
place it
we'll
on
file.
record so that
Please,
they will also know what the
Please.
reasons are. Yes, learned.
Pendant said the case. Can't deport him.
please, my lord, I'll put it on record.
Yes,
Pendant said the case is we can't deport. Huh?
Alala, the procedural delay is what is causing him, holding him back, because he is in the detention center. He has to be provided with counselor access. So that is getting delayed. As otherwise.
and he is also not identified.
No, he's not identified.
You had said
Once
that.
the identification is done, thereafter the procedure starts.
Are you, appeals are pending, can you deport him back?
No, my lord,
What is that law which bars?
I'll place it on record.
No, the
Please.
court,
Yes, yes.
in the appeal, court would bind him. So based on that only we can hold him back. The court doesn't bind, my lord will not have any, yes, because it is posted on 12th.
Yes, learned counsel, learned DSGI as well as the learned SPP seek further time to place objections on record. List after a week,
2 weeks, because it is coming up on the 14th, I think.
whether it comes up
Yes,
or not, that is not the issue.
No,
You
there is
must
some.
place it on record as
We
to,
will place it on.
yes, after a week.
18th February. List number 1, number 2 for admission, Sri Mukkanappa SP.
Yes, with continuity of service, but without back wages. Are you entitled to notional increments is the question. Yes, yes. Yes,
Number 3. Government advocate.
yes.
A date may be fixed, my lord. No, my lord.
Listed for admission today, 13/2/1992,
Yes, my
he
lord.
was appointed. Admitted to grant on 1/6/2019 after a litigation. Annexure K, that is prospective. There was the finding of the learned single judge is that there was a post available in the staffing pattern, and government is directed to consider
Yes,
noting that he was appointed in 92.
Yes,
There
my
was
lord.
a staffing, a post available in the staffing pattern when he was appointed, and that he was not admitted to grant, not on his account.
Yes, my lord.
These are the facts. So what is wrong with the finding? Page 50, para 12 and 13.
Date may be fixed, my lord. Next Monday, my lord. No, no, this is not today. No. No. Next, next Monday, my lord. Next Monday. No, my lord. Next Monday, my lord.
This on Friday, last chance. If you don't argue, your appeal
Yes, ma'am.
goes.
Friday.
We have
Friday, my lord.
considered this matter. We have read the judgment.
Yes.
Unless you can place something on record to disabuse us of
Yes.
our views. Yes, learned counsel, as AGA seeks further time to argue the matter for admission. Time is granted as a last chance.
Yes, ma'am.
List on Friday.
14th
It
February.
is not argued, that is the end of this matter.
Number 4, please submit yes.
Yes,
During the course of the day, I will file my affidavit, my lord. Course of the day, I will file my lord.
please see the result
ಬರ್ತಿದ್ದಾರೆ, file ಮಾಡ್ಬೇಕು.
in favor of the Nagaraj, who sells the file. There is no current record published. These are the And then there is later, 7 acres, 20 gunters is granted to the society. That is limited to 5 acres. What is the 5 acres which is granted to the society? We should have heard. If there is anything left, let Nagaraju or his assignments claim. That is all. Yes, who do you appear for? For the appellants. You are purchasers from Nagaraju. Question is only whether Nagaraju had a grant or not. As far as the society is concerned, 7 acres, 20 guntas was initially granted to the society. That was limited as 5 acres. Now your contention is that it overlaps your property. You don't have anything to show that. Absolutely, then what is the difficulty? There's only they now claim only 5 acres. What does it say? Whether it is beyond 5 acres or not, it will not affect you so far as you have not been able to prove your possession or your grant. No sagvalliche, nothing. Which does not show anything. We had seen the sagvalliche extract. It appears that there is some kind of an a post-dated entry. That is all it reveals.
The revenue report from the year 1970s onwards stands undisputed in revenue until the computer RTCs came into force. My name is removed for the first time in 2003 with the computer RTCs. And subsequently, I approached the revenue. And it is subsequent to that, all these.
When, according to you, is your grant? 1965, if I'm not mistaken. Nothing to show the grant. What else do you have to show that there was a grant? When? Where? Next year. Different. Please place the affidavit on record. We'll
Please,
hear
sir.
it on another day. Please be ready on.
For Saturday, I will fail, my lord. Today, I will fail, my lord.
Please, learned AGA submits that the affidavit as directed is being placed on record today.
Yes, ma'am.
It must be a proper, clear affidavit. Otherwise, you don't, only because we may not need it. But when it has been directed to be looked into, a proper affidavit must be on record. Please
Affidavit,
be
sir.
careful when you're drafting that affidavit. Yes, list on Thursday.
It is.
13th February.
Never mind that. That is for our, yes, it's all right. We are waiting for that. That's all right. We understand. Please be ready on Thursday. That's all right. There's no need for an apology because we had asked him to, you probably were under the impression that is what it is. Yes,
For 5,
till then.
As interim order is concerned, I oppose because they are claiming right only on.
Let's see, it's only till Thursday. Yes,
December 5, Sri Joshua Hudson Samuel.
One number.
yes. Pass over.
Pass over. Chamber 6, Shri Abhilash Raju.
Permission to file. You've not been permitted.
Lords, in 6, may I pray for Wednesday, my lord, some personal inconvenience. May I pray for 6, my lords?
Yes, learned counsel for the respondent seeks a short accommodation list on Wednesday.
12th February. Chamber 7,
AOC lecturers,
Pimpirina.
absorption.
Shri
Yes,
Basuraj Patel.
in which matter? 3 for bringing an IA 3 of 24 for bringing a loss of deceased petitioner on record. Can be allowed.
Yes. Son, I also.
The thing is, the statement is what about there's a filing delay in one of these matters? Who appears? In item 749 of 2020. 393 days in filing the appeal?
Government advocate.
Statement.
No, that is the respondent. Who appears for the appellant there?
Suraj Patel.
Shri Basuraj Patel ji ke.
Pass over, let's see.
Pass over.
Service ಆಗಿದೆ.
It appears at
ಆಗಿದೆ.
R4 to R25 dispense.
Dispense with.
Where is he?
The orders passed. Orders on I one of them. Acceptance was from the year 392 days in time. Yes.
This is for admission.
Hearing
Early hearing, it's already admitted.
that again.
Is it an
If it's
admitted
not
matter?
admitted,
Ready notice ಆಗಿದೆ. Ready notice ಆಗಿದೆ.
matter is not yet admitted, hence pending a application for early hearing are rejected. List on search for admission.
Please argue for admission.
24th.
Government advocate, please be ready in this matter.
24th.
This is Vishwesharaya.
Hello.
Actually, very good things.
Yes, sir. Appearing dismissed.
Detention. Why say by a call teacher for a look only.
ಅದು IAS ಅವರು.
Yes, this is
My lords, the-
Vishwesharaya.
Vishweshwara layout, my lords.
Lapsed, held to be lapsed in respect of the
Petition lands.
subject property. What
Subject
is
prop-
the extent of the property?
Lord, extent of the property is 2 acres of land, my lords.
Hmm. Hmm.
2 acres, 5 guntas, out of 5 acres, 5 guntas in survey number 132 of Ullala village. Lord, we have implemented the scheme in full. The reason as to why, my lords, the learned single judge has come to that conclusion is because we have produced the petitioner as well as the respondent has produced a merger which seems to be predating the award. My lords. What has happened, my lord, is that the merger is done twice. One is prior to the passing of the award to know what is the status of the land. Second is at the time of 16-1, my lords, when we formally take possession of the lands. Unfortunately, my lords, when we produced it, we also seem to have mistakenly produced the same merger, but we have marked it in the objection saying that we are producing the merger along with this thing, but we've produced a wrong merger. I may be permitted to place the correct merger on record. We have also deposited the compensation to the city civil court, my lords. So it is not, my lord, a case that we have not completed the acquisition. And my lord, the scheme has been fully implemented. One of the recently, my lords, the last 2 decades.
This land, what?
My lords,
This land, what is?
this lands, my lord, we have gone ahead and developed the lands for Vishweshwara.
What is the date of Mazda? Mazda or whatever.
Lords, Mahajar is dated 10/2/2003, my lords. 2003.
Because 13/12/2002 is the award.
Yes, my lord.
After that.
After
a
that,
mahazar has-
we have passed March.
Actually, a proper mahazar has been,
Correct merger is now being produced, my lords. Lordship may kindly see on that lot, top section, under section 16, my lords.
what is 2012/2002? 5 acres, 5 guntas dry land, 4,49,000 per acre.
This was the entire extent, my lords,
Hmm.
132.
Hmm.
And my lords, then we have deposited the compensation amount in the city civil court, my lords.
Hmm.
What lordship sees at page 11, document number 3, is the details of the deposit.
Just a moment. Property of land acquired from 32 so and so. Bangalore North, sir, and Vishwashraya another layout. Compensation value of 5 acres, 5 guntas, total value of Malkis. 30% solation. Additional value 12% per annum. 31,43,793. Board notice sent on
2012-2002, my lords. Subsequently on 10/2/2003, my lords, is the section 16(1) proceedings, my lord. Mahajar is drawn and possession is taken. And
page
since-
10 is in respect of this very same property.
Yes, my lords, very same property, survey number 132, my lords. Larger extent, 5 acre, 5 guntas.
Full and
In
entire.
question is here is 2 acre, 5 guntas. So larger extent is taken, my lords. Possession is taken. And lords, my lords, the deposit is also with respect to the entire
5 acre, 5 guntas.
Mahajar is document number 2, my lords, page number 10. Under 16, my lords. Lordship may kindly see Bhuswadhina Kaide Kalam 16 prakara.
2003, no.
I'm sorry, my lords, I have not produced the translation.
Original of this,
That's all.
Please, my lords.
original of this.
Original of it is in the file, my lords. We have it in the file. I have seen the original file and taken this copy from the original file, my lords.
This reference, the award, we can be found. The award, whether this reference is there, this date of.
Mahajar, my lords, this is the subsequent to the award. Subsequent to the award.
In
Our-
16,
our- 16(2), my lords, we have, my lord, the objection statement says that we have even given 16(2), my lords. I could not find, normally 16(2) notifications are kept separately, my lords. They are not kept along with the original file. In the original file, I was able to find 16(1) as well as the deposit, my lords. 16(1), what they do, my lord, 16(2) lordships would be aware. It is done at once for all the survey numbers, my lord. It is not done per survey number. So therefore, the objection statement says so that we have done 16(2), my lords.
Contract where you have handed over to engineering department, that is there? Have you checked that? That also, so that.
That my colleague tells me, my lord, it is there, but I have not produced it as a document. It was not there before the learned single judge also as a document.
Notices.
Issue notice. Page 8. Delay, law.
Delay is no delay. I filed an application for stay, my lords.
Not there doing.
Possession, my lords, we have gone ahead and formed the layout. Allottees are there.
The. By inadvertence, they could not produce the mercer for having taken possession of the property before the land single judge. Now, he is placed along with the memo. It is further submitted that the entire compensation amount pursuant to the award has been deposited to the civil court and possession is taken thereafter. By consideration. Hence, there shall be supreme order of state with regard to the possession, parties are in view of the same, parties are directed to maintain status quo with regard to the possession as on mistake. Issue emergent notice, DG is requested.
Obliged, my lords.
Number 9, government advocate.
Statement.
Undervaluation.
It just takes steps in few matters, concrete matters, my lord.
Get the steps. We argue the matter. Then the issue can be settled once and for all. And in all other matters, it can follow.
May post it
One
tomorrow.
matter which is,
Main matter.
9.1 if it is taken up, my lord.
yes, one matter which is fully served, we can take up and decide.
Tomorrow, my lord. Right.
The big order is there, we can see that.
Supposed to be, this also doesn't, I don't think it is a
Or you will argue or somebody will
Age will argue, madam.
say,
Rubin Jacob. Rubin Jacob, madam.
AGS.
Instead of tomorrow.
Additional Advocate General, the Rubin Jacob is not available today. List on so and so. Have the
Tomorrow day after tomorrow.
Is agree a date.
check.
Agree a date.
Wednesday, madam.
After,
Wednesday.
Didn't come every matter.
I would
is safe.
request my lords, after 18th till 16th, I have some difficulty. 18th, and because my lords, I am unable to concentrate on certain court issues, that's.
List on 18, 19.
Quite a huge difficulty.
19th, 19th February,
9,
Agate,
16th ಗೆ election ಮುಗಿಯುತ್ತೆ, since that's why.
19th February,
please go and tell additional advocate.
number 10 and 11 adjourned. Number 12. Sri Timmegowda.
MBBS increase in take.
But the increase of the medical seats,
Hmm.
150 to 250 seats, madam.
Hmm.
But the last date is 18/1/2023, madam.
Hmm.
Madam, on that day only at 4:54,
Hmm.
I have received the essentiality certificate from the government and as well as the application certificate from the university.
Hmm.
Therefore, immediately I made attempts to the in application.
Hmm.
In portal is showing, my lord, kindly see the ink page number 25, my lord. Ink page number 25, my lord, showing that transaction is pending from bank.
Hmm.
Please await in confirmation of the successful completion, etc., my lord.
Hmm.
My lord, thereafter immediately I contacted through email communication to the NMS, NMC council.
Hmm.
Then, my lord, at 9:41 PM. Then again on on the same day, 9:47 also communicated to email. Even next day also, my lord, I communicated to the email. Even as on today, my lord, they have not informed, not any given any response to the my request, my lord.
The place for it.
NMC is Mr. KT, my lord. But increase of intake, my
Yes.
lord, by now it will be too
I
late.
saw the copy.
For
I
now
saw
it is
the
too
copy.
late in the day.
I know, there's
Since-
nothing that can be done at this.
Yes.
Let them say what happened in the.
Please.
Yes.
My lord, kindly fix the date for hearing, my lord.
Yagesh, want our us to issue notice or not? Notice is not at all.
Not at all, my lord.
ಮಾಡೋಣ ಬೇಡ
ಮಾಡ್ಬೇಕು. ಅಲ್ಲ,
ಅದೇ
ನೋ-
ಮಾಡ್ತೇವೆ
ಅಲ್ಲ, ನೋಟಿಸ್ ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಫಾರ್
ಆಗ್ಲಿ.
ಹಿಯರಿಂಗ್.
Notice ಆಗ್ಲಿ, ಒಂದ್ ನಿಮಿಷ
ಸರಿ.
ದಯವಿಟ್ಟು third AGS request notice for R1 NKT no request to accept notice for R1 for R3 request to accept R3 learned counsel to the petitioner shall serve copies of the petition and annexes to the respective councils list on next week on it at least
20th February,
ಮಂಚೂರು.
December 13, Sri Sunil Rao.
Again, eligibility, reduction. You become qualified only on 15th by the notification dated 15/1/2025. What can be done? Let them take notice.
ಬಂದ್ಬಿಡ್ತಾರೆ ಸ್ವಲ್ಪ ಟೋಟಲ್ ಒನ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಬಂದ್ಬಿಡ್ತಾರೆ
notice ಬೇಡವಾ
ಬೇಕು ಪಾಸ್ ಅವ್ರು
Pass over. Hearing on IA, number 14, Sri P.N. Manmohan.
For the appellants in this case, my lords. That's a
Years of
five,
deceased A4,
yes, my lords.
A7.
A7, my lords, we have filed application to bring LRs of A7, my lords. In one of the LRs did not join the other appellants, my lord. Therefore, notice was issued to respondent number 2, my lords. We have paid the PF on 9/7/2024, my lords.
4 and A7,
A to R2
A2 to A10 are treated as LRs of deceased by A1. Then again, there is A4 and A7.
A7 is
A7, A4 and A7 appears to be by order dated 3/9/2022. A2 to A10 are treated as LRs of deceased A1. A4 and A7, I think we can do. A4 and A7, I think we can do. He is appearing for the LRs of. A4 and A7, those applications can be allowed. Is there anybody who's not, is
Well,
there
that's,
anybody you are not representing? LRs of whom?
my lords, I'm for the appellants, my lords.
I understand. You said notice had been issued to one of the LRs.
Yes, my lords. Appellant number 7, my lords.
Plan number 7
Right now.
is the
Yes,
deceased.
my lords.
How can notice be issued to him?
LRs of A7, my
Who
lords.
is appearing then?
My lords,
He's for-
Is for this one, not the appellant,
Oh, he's not for. Yes, if
who appears for the A1 to?
proposed LRs, you appear,
yes, my lords.
all of them.
Yes, my lords. Only except one, my lord. That's why we
Who is that
wanted to
exception?
issue.
Who's that? person?
Respondent number 2, my lords. It's not, they've not yet been arrayed as respondent number 2, my lords.
Respondent or appellant, madam?
My lords, LRs of appellant number 7, my lords.
Hmm.
Now, appellant number 7 has died.
Yes, my lords.
This is all issued.
Yes, notice has been issued, my lords. We are appearing for all the appellant.
All the LRs.
All the
That
LRs.
can
my
be
lords.
allowed.
Yes, my,
How much?
except one, my lord. She is not joining the appellant, my
that?
lords.
It's partition, is it not? No, it is.
Shailaja, my lords.
Respondent number, appellant number 7, no?
7, my lords.
7,
Is that
8 to E.
application?
It is to bring A7, A2E, to bring on record the LRs as A7, A2E and R2 can be allowed.
And respondent number 2, my lords.
She does not want one,
That will be R2. That person will be R2. It is the IAS for that. To bring LRs of deceased A7 on record as A7, A2A, A2E and R2. A2E and R2. Can be
Orson, IA1 of 23rd, except in partial. The legal heirs of the appellant number 7, that is appellant number 7A to E are permitted to brought on record as the legal heirs of the appellant number 7. One of the legal heir, that is Srimati Geeta,
Shailaja.
has not come forward to enter appearance, hence she is treated as a respondent number 2 in the appeal. The appellant shall amend the first title and file amended first title accordingly. What about the R4?
A4. A4 can also be
Yes, my
brought on
lords.
record.
Yes,
All of them.
All of them.
A1 of 25, except in partial. Case is allowed. Appellant number 4 legal heirs are permitted to brought on record. The appellant shall amend the first title and file amended first title.
You've already filed wakalat for R1, A2, A2I.
Number 15, the T. Prakash.
That I represent the appellant in this case, your lordship may kindly grant 1 week time in this case, my lord. Because yes, we have only fixed that hearing, but unfortunately, we have misplaced the certified copies of the document. Only paper book is there, it is a typed copy. The certified copies are necessary to be seen. Because always paper book we cannot rely upon because some of the typing errors might be there, my lord. Next week without file, I will go on with it.
Submissions to them. There's a very limited point involved in this.
Madam, we are the appellants, I am the appellant.
The interfront degree holder.
I have only agreed for final hearing. I have no doubt on that. But next week I will get the certified copies and I will add. Madam, repeatedly you are saying the same thing.
Because repeatedly you're taking a.
Finally,
Yes, madam. Yes, sir.
Yes, on that date.
Yes, madam.
Yes, learned counsel for the appellant seeks further time to get ready to argue the matter. Time is granted finally. List on, give a date. Please give a date.
Publish.
27th February.
Yes.
Interim ordinaries.
Number 16, the Narayan Rao HR.
Short accommodation, madam.
1612 days.
Madam,
delay.
not maintainable earlier, they challenged it, so dismissed it.
My lord. My lord, it is not dismissed, my lord. It is not dismissed on merits, my lord. We have permitted to file a review petition before the court below, my lord. Your lordship may kindly peruse page number 27, my lord. Page number 27. One ನಿಮಿಷ ಇಲ್ಲಿದೆ ಹಾಕಿದ್ದೀನಿ ಸರ್ appeal memorandum. My lord, page number 27, operative portion is page number 29, my lord. This appeal arises out of the impugned order dated so and so, passed in the miscellaneous number 25049 of 9 by the additional citizen so and so, allowing the petition filed by respondent under section 260 of the Indian Section Act. We have heard Sri Rajeshwar PN, learned counsel appeal for appellant for quite some time. During the course of submission, he submitted that the instant appeal may be dismissed as withdrawn, reserving liberty to the appellant to file a review petition, which 1 week from the date of receipt of a copy of this judgment and all the grounds urged in the appeal be left open. The said submission of the learned counsel appearing for the appellant is placed on record. In the light of the submission of the learned counsel appearing for the appellant, as stated supra, the instant appeal is dismissed as withdrawn, reserving liberty to the appellant to file a review petition for review of the order dated so and so, passed in miscellaneous number 25049 of 9 by the 4th additional city civil judge, Mayal Unit, Bangalore, within 1 week from the data. Thereafter, my lord, that review petition I have enclosed along with my delay application, my lord. My review petition has been dismissed, my lord. Now I have questioned the original order passed by the because this appeal, earlier appeal, has not passed on merits, my lord. My lord, I will place the citation, my lord. Seek weeks accommodation, my lord. I will place the citation, my lord, because that order passed not on merits, my lord. Even my review petition order is also, my lord, not considered.
There is an order in the review petition.
My lord,
Should
we
you
will-
not also challenge it?
My lord, we will place the citation, my lord, regarding the
Unless of course
maintainability.
it is rejected without even, is that the case? The review petition was rejected without considering anything. Is that the case? No. Notice was ordered in the review. Review was considered, an order was passed. Why should you not challenge the order? What is the citation you want to place on record?
That, my lord, the original order,
Review is considered an order passed.
review,
The order in review also not be under challenge.
They can challenge it.
Of course.
my lord,
Along with this, you are required to challenge that order also.
my lord, then I request, my lord, kindly grant the week's account necessary application will
2020 appeal.
because some LR application has to be brought, my lord, last week, last occasion. I have, my lord, filed an application.
May not help unless
My
you
lord,
have appropriate prayers. Now
My-
at this distance of time, there can be no appropriate prayer also because 5 years have passed since the appeal is
my
admitted.
lord, grant the
We are
days
not
account.
considering a writ petition, we are considering an appeal. You cannot grant time which is not available.
My lord, grant a days accommodation, my lord. Place the reliance on.
Yes.
Next week. Last chance. Do whatever, thereafter you don't come and ask. me.
Yes, please. 19th February,
Listed it as last chance.
please. Number 17, Sri Nishant Devi.
For the appellant, my lords. My lords, on the previous date, my lords, this honorable court permitted me to comply with the office objections subject to payment of 3,000 rupees cost. My lords, with respect to cost, I have filed a memo. There's a specific direction to pay cost for High Court Legal Services Authority. And that, my lords, there is no High Court Legal Services Authority. When I went to pay cost for Karnataka Legal Service Authority, they are not accepting the cost.
Which direction?
There was a direction to pay cost for High Court Legal Service Authority, my lords.
Good committee.
But it was authority in the so if I'm permitted to,
Pay and come back.
There is
Pass
no-
over and inform the court officer. Court officer, phone ಮಾಡಿ ಹೇಳ್ತಾರೆ. Court officer ready. The authority is but pass on. Record. Go and pay and show the receipt.
please, my lords, in the course of the day, I'll pay.
Counsel for the appellant subject that the day we pay the cost. It is further submitted that all the office objections have been complied with.
Please, my lord.
Date submission is placed on record. View of the submission, order delay of 8 days in filing an application to recall is condoned. Order dated so and so is recalled, appeal is restored. List for admission. But you subject to this showing the
My lords,
Today itself.
My lords, there's a delay of 3 days in filing the appeal, to which my lords have filed an application on fifth
Sir,
February.
ready or- See the papers. and
Please, my lords.
already-
Please pay the cost and
Please, my lords.
December 18, Sri S.V. Prakash.
Lord, I appear for appellants, my lord. Claimant appeals for announcement, my lord. There is a delay of 1,369 days.
360. Notice it also.
One set of copies.
Two consent.
The copies are not served.
My lord, I will serve the copy, my lord.
Why you are not serving? You should notice. Delay.
My lord, 1 week time may be granted, my lord. I will serve the copy. And
The request to learn cost for the appellant. List on so and so to enable him to copies of the papers to learn SCG. List on
20th February.
much obliged.
December 19, Sri Rajendra Care.
Partition suit.
This is not against the final decree proceedings. There is a delay, my lords, in filing the appeal. The reason, my lords, was originally, my lord, we had preferred a writ petition challenging the order of, no, there was a mistake. Then, my lord, this honorable court permitted us to withdraw the writ petition and prefer an appeal. Therefore, there is a delay. Para 7. my lord.
For the respondent number 1 in this case law. If the copy is out to me, I will file a necessary objection.
Delay petition copy is not served.
Not sir.
Notice
First
has
time.
been ordered.
It is coming up for the first time, I'm told. We'll serve a notice.
you sir, you take
Please.
copies. Delay can condone, no?
No, my lord, I will file a proper objection because
I,
last from 25 years.
I all.
Please.
In all the incident counsel for the appellant. So and so. for the respondent.
yaar appear.
Respondent issue notice on I 1 of 24 as well as on May. List on.
But sir, for others also notice may have to be issued because, please,
Notice on I as well as on.
please,
May.
please.
Process also.
Yeah,
May.
we'll pay.
Addition to that, sir.
Please. I will file.
Any date, after 2 weeks, any date.
List after 2 weeks.
3rd March.
3rd March.
December 20, Sri Care Lingaraj.
765 days.
Correspondent number 2. Today I have received a copy. They have served the copy.
This matter,
Yes,
this matter is covered by judgment of this court, my lord. The reference court has enhanced the compensation to 20,000 per acre, buntas. My lord, this
Yagachi
court,
Reservoir.
my lord,
Yagachi Reservoir.
please, my lord. But insofar as this court, my lord, by considering the coordinate bench judgment, my lord,
1 lakh per
per
gunta.
gunta, 1 lakh, my lord. And also, similar delay had been condoned by a coordinate bench, my lord. This is the order of.
There is no similar order in a delay
My
petition.
lord, insofar as the delay is concerned, my lord, the order has been passed during the COVID, my lord. And also, the appellant mother had suffering a breast cancer, my lord. I made reasoning.
The first 4-5 hours.
Please.
My submission is, my lord.
Shall
Lord,
is
one
too
stretch
strong
of-
opponent.
It is one stretch, my lord. Yagachi is from, one stretch it is, my lord. We cannot, my submission, my lord, is, my lord, 1 lakh they are claiming, my lord, but they have to prove why. So 1 lakh, it has to be given, my lord. Potentiality of the land should be seen, my lord. They are not giving any evidence, my lord, before the court, but directly they are coming with a judgment telling that it is covered by judgment and
Delay.
delay, I will file my objection. 765 days.
Whenever you will issue copies.
Today I have received the.
Sorry, my lord, copy.
You got copies.
Judgment on translation of copy.
Is the judgment.
While translated copy. Otherwise, Prashant will go
But-
and SLP first round is that.
This,
That is not.
this judgment is mixed with English and Kannada, my lord.
I will make it to English now.
Please, my lord.
Just translate for the on number 2.
Only the
List
judgment.
on,
Please, please.
list answer. The disposal agate. Even if after 10 years also we are going to pass the
I
same.
agree, my lord, I
Why you
agree.
want to keep that 5?
No, 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 I agree, my lord, but it is a big stretch, my lord, it is my sir.
All benches are considered.
This is adjacent land, my lord, adjacent village. There is no difference.
That on merits it has gone now.
In
In regard to
Supreme,
this case, my lord,
even
I have
Supreme,
argued on merits, considered and it was passed.
even Supreme
That
Court, my
I-
lord, elaborately says, my lord, insofar as adjacent land is concerned, there is no, if he grown coffee, if he grown banana tree, there is no question of discriminate under crop. This is the, kindly see the fertility of land. Please, my lord,
Fertility comes only if some other judgment comes.
please,
Before that, no.
21st February,
please,
21st February,
File
number
a translation.
21,
please.
21, Sri Bipin Hegde.
Lordship, this honorable court on 27/11/2024 is directed to announce the results. In the event she fails, she is permitted to take the supplementary examination. I have taken the supplementary examination and my results are withheld. I filed for declaration of results, my lordship.
Goes on and on and on. Yes. This goes on and on and on. Well, where have you reached now? Which year?
This I have for the first year, she has to attend for second year, my lordship.
Only first year.
First year,
So we can hear it on merits.
please. They have to,
So we need to give.
they have
What
to.
was the reason? Percentage.
Percentage, no?
No, madam.
No, my lordship.
I think this is a last minute admission case.
Admission,
Oh, not,
last minute.
Without KA.
Without KA.
Without.
instead another student was.
Without KA.
Sans KA.
They have to file objections.
Just wait, let them appear. Now 6 things.
And let this go on and on.
We will argue on the merits itself, my lordship, date.
It's the only way to go about. So when?
They have to file objections immediately after.
We'll take it. Any date may be fixed.
Date.
Yes, give a date. The Learned Council for respondents. A director to place objections on record, list on
25th,
2 weeks.
Any day,
25th February.
20. Not, can it be
A will be
20, that particular week, next,
sure,
Yes, sir.
1st of March or 2nd of March
Third March.
first and second week.
is a holiday
Weekend,
weekend.
third of March. 3rd of March.
Third
Yeah,
March.
IA will be considered along with the main.
please,
No, we can't keep doing this.
please.
That may be a good
E
idea.
group matter, number 22, Sri Suraj Sampath.
This was the matter, my lords, where the marks was above the cutoff, my lords, but they issue me a letter and terminate my admission based on the fact that allegedly it's lesser than the cutoff.
We pass over? Hear this? Pass over?
Council.
Sorry, minutes. This is one thing taken place on 7th of February, minutes. My submissions may be taken on record. These proceedings have not been signed because it was subsequent Saturday and holiday, minutes. They have taken a decision to withdraw the discharge orders and regularize the admission.
We can record that.
Please, on the instructions, my lordship may put.
It is submitted by the learned. It is submitted by the Learned Council appearing for the first respondent university. That she has received instructions from the registrar of the university that a decision has been taken by the syndicate
Please, minutes.
of the university to recall the orders of discharge which are impugned in this writ petition. The said submission is placed on record. The writ petition is closed, recording that the orders which are under challenge will be recalled at the earliest.
Well, lords, if I may just clarify one thing. The university would issue annexure R internally to the college.
That I have not challenged. I have challenged what the college issues to me under Annexure A.
The internal communications issued by the university to the college, which are produced as annexure R,
R.
will also stand recall.
Please.
Consequently, will
Please.
also stand.
Please.
Yes.
Mashallah. The The university is responding. Respond number 2, my lords, my lordship has respond number 2.
The university is responding. Oh, yes, sorry, not R1, R2. Great.
Obliged. Number 23, Sri Venkatesh R. Bhagat.
My lord, in this case, I appear for the appellant, my lord. I apologize for appearing in VC, my lord.
Absolutely no need.
My lord, I pray for a week's time. I'm trying to get an instruction from the client to take necessary steps. A week's time, my lord, I will take necessary steps, my lord, to bring the LRs.
R3 to R5, R10 to R12, R14, R16. Yes, week's time granted as a last
Please,
chance to do the necessary.
Number 24.
Last
Sri
chance, counsel.
T.
Please, my
Sheshagiri
lord.
Rao.
For appellant notes. I might require 3 days. plus I
Here
do.
for respond number 1 and 2.
Week's time is back. Steps. Yes.
Number 25, Sri Venkatesh P. Dalwai.
Appellant is dead. The appellant is dead, my lords. I have to contact the party or I'll issue notice and retire. Because managing partner is no longer there.
Who will pay money?
But I'll pay from this thing, not an issue, but I just wanted to, I'll just get their instructions. Appellant is dead. It's a firm represented by managing partner. He's no more. I'm trying to get in touch with their children. So 10 days, my lords, kindly accommodate. I'm sorry.
Weeks time to take these steps. List after 2 weeks.
26. Srimati Annapurna.
For appellant. For objections, lordship will serve the IA number 2 of
On
2000.
taking steps in respect of
IA number 2 of
non-filing of paper book, non-compliance of office objections. Bill is not ready for hearing, service not yet completed, paper book not yet filed. Is paper book filed?
Yeah.
Not yet, my lord. Paper book has not been filed.
Lordship,
I
please
have
grant-
filed my earlier hearing application in the year 2016. That has also not been considered. Your lordship may kindly see, the 7th respondent is the person in whose favor 450 acres of land has been acquired for the project of IT company. His land is about 38 guntas in the entrance stage. So we purchased the property, deposited the amount in the name of the minor. Minor filed the suit for partition. After contest, the suit came to be dismissed. When this matter came up before this court, the court also did not grant injunction. But the entire project has been stalled for the last 19 years, my lord. 2014 is the appeal. 11 years office objections have not been complete. Paper book has not been.
Paper book, grantly 3 weeks, 3 weeks, please.
2014 matter counsel. What is the reason for not filing the paper book till now?
Please grant at least for 3 weeks. We will file the.
In other steps, only.
At least for 3 weeks.
Also for the appellant.
My lord, one submission. Please order for the hand summons for respondent number 2, respondent number 2 to 4 and respondent number 7. Because the respondent number 2 and 2 to 4 are the sisters of appellant, so.
Third time to
Third
comply,
time. They are okay.
office objections. Matter is listed for non-furnishing of process cover. We should notice to R2 to 4, 7 for third time, comma, non-taking of steps to bring LRs of R1 and R24 on record, non-filing of paper book, and non-compliance of office objection as a last test. Current counsel for the respondent, admits that the appellant is not removing the office objection, not showing any interest in pursuing pay from last 10 years. Purposefully is delaying the proceedings. This submission is placed on record. Taking note of the request of the learned counsel for the appellant. Finally, 2 weeks time is granted. Finally, 1 week's time is granted to furnish PF. And 2 weeks' time is granted to bring legal heirs of the deceased respondent on record. And 3 weeks to file a paper book, failing which appeal stand dismissed without any further reference to it. 3 weeks to the paper book, 1 week to the process, 2 weeks to the LRs.
Yes.
Do whatever, otherwise appeals dismissed without coming to the bench.
Okay, Lord. Sure, thank you.
27, Sri R.A. Devanand.
Legible copies. It is
I
listed.
have with me the 3 copies of the paper book to be filed, which I will faithfully do the needful today. And secondly, this suit falls within a very short compass. The respondent is the plaintiff, who is my adopted son. He was adopted at the age of 7.5 years. I am a appellant is the mother, adoptive mother. She is working as a scientist in NAL, National Aeronautical Laboratory. By borrowing loan from the employer, she purchases the house. At that time, my adopted son was 8 years old. And a suit for partition is filed and decreed. These are all the question. It is an admitted fact. Property was purchased at the age of 8. He was adopted at the age of 7.5 years old. It is there. The record would speak. That's a very short question that would involve whether the trial court was justified in granting a decree for partition and possession, holding that he also contributed his share in the property, therefore is entitled for a share. Could it be listed sometime next week?
Copies are ready?
I will send a copy to the other side today.
Yes.
Can it be shortlisted in sometime in the next week for final hearing?
From the side. He also filed a paper, he said that he would file a paper book today itself. The submission of objections are overruled. List for admit agidea, sir.
Admit with stay. Somewhere in 2016.
On so.
Can a date be fixed, my lord?
25th February.
File the paper today only.
Number 28, the Prasanna Via.
In this matter, my lord, regarding objections number 1, my lord, item number 1, non-filing of amended cost title. I have filed the amended cost title on 3rd December 2022 itself, may. The order passed in the on 3/6/22. I have filed the
Yes,
amended
next.
cost title.
Next.
Next, IA number 1/23 to 3/23, bringing the LRs of deceased respondent number 16, in which the notice is not at all ordered.
Then calls for the appellant submits that amended cost title is filed on 3/12/22, registered to verify. Issue notice on IA 1 of 23,
1, 2, 3.
2 or 3 of 20. Next.
Regarding the item number 5, my lord, IA number 4, bringing the LRs of deceased R7, my lord. I have filed the one set of papers. It is my mistake, my lord. I may be permitted to file one more set, my lord.
You have a copy? No.
Today itself. Can you file it today itself?
I will file my.
Learn counsel for the appellant submits set of 4 to 6 will be filed within 3 days. Said submission is placed on record. Issue notice on the aforesaid IA.
Regarding
Seven.
item number 6, my lord, IA number 7 is filed by the
Fine.
respondent.
Me
my lord.
respond number 7, me filed
Hmm.
before the single bench earlier, it was
Hmm.
to this bench lordship.
There are office
I will
objections.
file.
There also second set is not
Yeah,
filed.
second set I will file within 3 days.
Shall comply.
Within 3 days, I will file second set.
For which I
Kindly date may be fixed, Lord.
objections to their application,
Hmm.
but it was.
That also second set not filed.
The second set, because earlier.
week's time, a special court is required, I think.
Kindly,
Due to division bench sitting here and.
Lordship, I requested to,
Xerox copies may not serve the purpose, I think. Another
I
2, 3
requested to
benches are
fix it.
required.
Why is all this required? Why can't you just do it in the, once you see these
yes,
office
Next.
objections, why
Yes, yes.
is it not
Week's
removed
time is
immediately?
granted to comply with objection on pending applications.
Kindly.
IA7 of.
There is urgency. There is urgency on IA number 7, Lordship. The entire scheduled property is acquired by the KADB.
Then all.
That is it.
File the second set, please.
Connect
There's a
with the
cross
external-
objection also, there also there appears to be office objections.
Yes, Lordship.
Furnishing of
where-
FPF cover acknowledgement,
Week's
etc.
time
to issue
granted.
notice.
cross
Do it
objection.
immediately, please.
Week's time. Cross objection.
Number 29, TK Ramchandran.
Paperwork. Team.
For the appeal in 3 weeks' time, my lord, I will file my paperbacks, my lord.
Manisu.
2015, why so much time?
My lord, there was some typing, everything is ready, my 3 weeks, 3 weeks' time, my lord, as a final chance,
The cost of the.
as a final,
Standard cost.
as a final chance, my lord, if you are, I agree, my lord.
Finally, 3 weeks time is final.
Please,
Number 30, Sri Unnikrishnan.
340 days.
APF for appellant may not
File.
PF paid may not.
Transfer that as PF is paid. Registration fees. Yes.
AGF.
Number 31, Sri Monesh Kumar KB.
For appellant in this matter, I pray 1 week's a slight inconvenience today, ma'am. 1 week, sir.
20 days.
What are the objections? What are the objections?
They filed IA number 1.
Objections on IA. Delay.
Maybe, hold on.
Thing itself is the cost. Feel of IA.
Copies.
2020, you are not complied with the office objection.
I took this. The office objection, I took copy. The copy is not being served on me.
Copy
They
of
will have
what?
to serve a copy of the petition, my lord. That is not, sir. My learned friend has,
I see. Those are the office objections.
I pray 1 week.
5 office objections. are pending.
Yeah.
Very-
No.
very-
It has to be.
IA 1 of 20 to 20 days may be condoned.
First you comply, otherwise we are going to dismiss this appeal.
1 week's of time, my lord. I'll comply by then.
We'll impose a cost and then grant.
My lord, finally, 1 week's,
The grant of
as a final chance, my lord, I'll do it on 1 week's.
the request, week's time is granted. to comply.
Deeply obliged.
Please do the necessary immediately, Council.
Definitely,
This
my
is
lords.
such a waste of judicial time.
I apologize, my lord.
The least you can do is look up what the objections are at least.
Number 32, Srimati Sujata BA. Sachin BS.
My lords. And for the appellant, my lords, bringing legal errors of respondent number 2, we have wrongly state the date of his death, my lord, in the affidavit. It's only the objection, my lords.
Dismiss the appeal against them. So that everything will be all right.
My lords, the affidavit, 1 week's time may be given, my lord, so I will correct it, my lord. 1 week may be, 1 week time may be given, my lord.
It's a mistake.
The date of that death I have wrongly stated in the affidavit, that's all, my lord.
It's only an affidavit.
That's only.
It has to be corrected, appropriately corrected.
Red council for the appeal seeks weeks time to correct the error, the application, IA1, IA1, 2, whatever IA is allowed. Is granted. If office objection have been filed, issue notice. The application.
Much of them.
Save that time.
Otherwise,
You comply.
Please,
Otherwise,
madam.
issuance of notice another day. It will
Please, ma'am,
comply.
I will compare. Much of them.
33,
Otherwise, I'll add, if it is not complied, stand
It will
dismissed.
stand
Purpose.
dismissed.
This time is granted to comply. If office
Lords, I appear for the,
it is complied, issue notice.
Much of them.
Lords, I appear in all these matters for one of the
So I
respondents.
appear for the appellant in the first matter, my lords, in the writ appeal number 364 of 2022.
Yes, just a moment. Yes, what are the office objections about?
83.1 and there is no office objection.
33.1, there are no objections. There are no objections. Okay.
6 ready,
Statement of objections. Only no objections. What is this about?
Lords, this is in respect of.
My lords, if I may submit,
Yes.
if I'm, my lords, this matter, my lords, is we challenge the order of the learned single judge with respect to issuing kata, my lords. So this matter pertains, this goes back to as early as 2005, wherein there was a preliminary notification issued for the acquisition of certain lands towards the formation of DRDO, my lords, in Bangalore. Pursuant to that, what happened, my lords? Subsequently, after the preliminary notification was issued, a few lands were left out of the notification in the subsequent notification which was issued. Eventually, my lords, all these matters were challenged by the landlords, and the matter went up until the Supreme Court. And the matter went up until the Supreme Court, wherein both the parties, the SLAO and the landlords, file a joint memo before the Supreme Court, having settled the matter, telling that, okay, these are the lands which will be left out of the acquisition, and the rest of the lands will be acquired for the purpose of forming the DRDO, my lords. Subsequently, these landlords had executed a power of attorney in favor of the respondent number 4 before this honorable court. Service has been held sufficient. He's not been represented before the learned single judge also, and as well as before this honorable court, my lords. This respondent number 4, acting on the basis of the said general power of attorney, executes a transfer deed in favor of himself. The general power of attorney, my lords, does not provide any power for the respondent number 4 to execute the general power of to transfer the lands to anyone, much less the respondent number 4. Now, based on the transfer deeds, and it's the transfer deed which is executed. I don't see what, there is no description of what a transfer deed is at all. There is no, the transfer deed, nevertheless, the transfer deed comes to be executed, and then there are certain transactions that takes place as a joint development agreement also that comes to be executed. I challenge, and the khata gets transferred. I challenge the khata, my lords. The landlords before this honorable court, the appellants before this honorable court are all landlords who were parties before the learned Supreme Court and honorable Supreme Court, as well as who are the ones who executed the general power of attorney, my lords. These landlords now challenge the khata before the BBMP, telling that no, they cannot be issued khata. So the BBMP allows a transfer of khata, and after that, my lords, I come before this before the learned single judge challenging the issuance of the khata. The learned single judge dismisses my appeal, my lords, and I am before this honorable court challenging the said order. This requires a detailed consideration. In my respective submission, my lords, if a date may be fixed, I would require at least another hour and a half or 2, my lords, and we need detailed consideration. If a date may be fixed, my lords, if possibly at the court's convenience at 2:30, we will come and make submissions after preparing, my lords. There's a lot of fraud pleading. In fact, there are charge sheets that are filed by the CBI, my lords.
We'll consider. Just a moment. Who do you appear for?
I appear for the developer in all these matters.
I am the Khatedar.
He is the Khatedar.
I am the Khatedar. Your Lordship may kindly see. The Khata was made in my name in the year 2007. Pursuant to that, I entered into joint development agreement. 600 flats have been constructed. Now the owners have, your Lordship may kindly turn to in page 30. Learned single judge's order at page of para 5. A civil suit was filed for seeking identical reliefs. Civil suit was dismissed. Now they want to go into
this court to go into all these questions, which requires elaborate evidence, and the trial court has dismissed the suit. Your Lordship may kindly see para 5 of the learned single judge's order. These are the relief that was sought for. It has been dismissed.
OS 724 of 2013,
Yes, my lord.
challenging the very deed of transfer on the very same grounds.
All these things have been already adjudicated before the civil court.
And in a parallel proceeding, the matter went up to the Supreme Court, wherein certain fraud was played on the trial court by the same party. The appellant here. Matter went up to the Supreme Court. Supreme Court said, dismiss the SLP. And orders were passed by a single judge of this court for an inquiry as against the appellant. Well, 660 families are staying there, khatas have been issued.
Yes.
Where himself has no power to execute the power for himself settled. That is the issue only this point.
Was that not the ground that you raised before the civil court?
After the Supreme Court matter has been settled, the matter before the apex court, the matter has been came back to the DRDO has directly to issue the land to the owner. At that time, this had been executed. That has
No,
been not-
you challenged it before the civil court. The
that issue has
deed has been challenged before the civil court on these. Is there an appeal pending?
been
RFA
Lords,
pending.
I will just submit this, my lords. A review was filed
Hmm.
as against this by them in the Supreme Court. Review came to be dismissed.
has been paid in respect of the
No, same thing, bringing out the same aspect.
power of agent.
Yes, now the issue has to be considered in the RFA.
It's been
As a
considered.
matter of fact, it is a civil appeal which has to be considered.
Yes.
This is only khata.
Yes.
The RFA is not before us.
No.
I don't think so.
This has to await the RFA. Ultimately, does this not have to await the RFA?
Absolutely.
Yes. The learned counsel for the appellants. It is submitted that an RFA is pending as against the decree in OS number 724 of 2013.
In RFA number 269 of 2017, my lord.
As RFA number,
Your Lordship gets at ink page 17, ink page 32, ink page
Kind of.
RFA number 269 of 2017. And the first line, the top line, Your Lordship gets it.
await the orders in the RFA. List after maybe a month or something.
मतलब the date may be fixed, my lords.
March 10th, sir.
For hearing the
Obligation.
RFA,
Which has been filed on that.
They have
Well, I'll
not
have
done
it moved,
anything in the
my lords.
RFAs.
So they are
My
not
ladyship, they have not done anything in the
been
RFAs.
served with this.
yes. It will have to await the decision in the RFA.
Yes.
Number 34, adjourned. Number 35. See, Prithvi Shemke.
Standing that will be heard today.
What is the matter about?
Regularization of employees working in Bangalore University over a decade, whereas similarly situated employees have been regularized. Now, their only contention is that it may cause some financial burden, but that is, lordships have observed that.
We have filed a,
You ready?
no,
Condens-
on 21/9/2023, we have filed a memo along with the documents. In that, we have rejected the proposal of the.
This is a matter, my lords, where 360 employees, my lords, were working in the Bangalore University. Then, my lords, about 85 employees were regularized. Then we are the original writ petitioners before this honorable court, my lords. There's a positive direction saying that the recommendations of the university have to be considered and we have to be regularized. That is the order which is challenged in the writ appeal. On the last date of hearing, my lords, they said that they will be positively considering, and now that they say
What
that
happened?
they have rejected our regularization.
I have
application.
copies of the memo
The
that's
copy is also not served.
not given to us.
Please serve copies of.
I'll serve the
all
copy, madam. We give one copy.
It was a compo.
We'll list it after a week. Please go through those orders and tell us what further to be done.
It amounts to, my lord, perpetuating the contempt. Lord, there is a positive direction.
What is the direction?
Please, my lord,
Page
kindly.
128 of the
Page
contempt.
126 is the direction issued by my lord, Honorable Learned Single Judge
Lord, it is a composite proposal of, my lord, 189 persons. In respect of, my lord, 86 persons, it was regularized.
Just a moment, where is the direction?
Page-
Writ appeal 569 of 2022.
569.
Please, my lords.
Page 126, my lord.
Content.
Just a moment, please, just a moment.
In content, my lord. Content.
569.
Yes,
Content.
Page number
126.
128 or 27.
20.
Please.
128 in the contempt paper book.
Contempt, my lords.
If it's the
128.
contempt, then it's page 128, my lord.
If it's writ appeal papers, it's 126.
I'm sorry, my lord.
Contempt 128.
Contempt ಅಲ್ಲಿ
20.
That's the same order means.
Petitions are-
petitions are allowed.
Orders,
Impugned,
all these-
order impugned in all these writ petitions stand quashed.
Hmm.
State government shall consider the proposal of the university sent on so and so. Other proposal recommendation so and so and pass appropriate orders in accordance with law. Bearing in mind the observations made in the course of the order, the university shall not shirk its responsibility of considering the cases of the petitioners for regularization of their services. In the event state government would leave it to the discretion of the university to consider the case of the petitioners for regularization. In the event the orders of regularization are passed by the university, the petitioners shall not be entitled to any arrears of salary, but would become entitled to count their services after completion of 10 years from the respective dates of their initial engagement for the purpose of determination of all other purpose condition and every terminal benefit. The
When
university,
were you engaged for the first time?
but in the year 1990, my lord.
Some of
I
us
was
in
appointed
96,
on
my lords.
1/4/96.
96, my lords.
Last being in 96.
Yes.
Even Umadevi does not apply.
After, now you have cancelled the proposal given by the university, my lord. Now,
Then you,
now they,
99 is the last.
Please, my lord.
99 is the last.
Hudson, 99. Please.
All the appointments, my lords, are before 19.
99, my lord.
And they have worked continuously in service.
in the event, the orders.
a
of
detailed order has been passed. Now they have to challenge this order, my lord. Why should? You consider your proposal. The government has considered the proposal given by the petitioners, my lord. A detailed order has been passed to that effect. Now they have to challenge that order.
University, my lords, has
When,
sent.
when there is a direction to this effect,
Yes, my lord.
in a writ petition,
But,
you don't have, it, which has not been tinkered with.
Not my lord.
As a matter of fact, how can you say
Page
this?
number 2.
And it was
And
the
they have
very
filed
same
a writ
similar
appeal.
orders which were quashed.
They have filed a writ appeal saying that that order cannot
What?
be done, and now they cannot reject our proposal.
128
This journey of the order to
at
consider
prayer.
in areas of wages. Then,
At,
when the learned single judge says, consider regularization,
Consider.
but don't pay back wages, what
Please,
does
madam.
that mean?
a detailed order has been passed by considering by looking into that proposal given by the petitioners, my lord.
Is that contempt or not is a question we are now asked to
Yes, ma'am.
consider.
Not a, the order passed by the,
There is already a contempt of court case
please, my
pending.
lord.
And when the learned single judge says that don't grant them the back wages of the regularization, what does that mean?
In fact, state is in
Now,
appeal.
Germany to notice the journey of the order to consider the result of such regularization, granting arrears of wages to the petitioners in the event of their regularization will mulct either the state or university and then place the state or the university under financial stress. Therefore, the petitioner shall not be entitled to any back wages once the benefit of regularization is granted to the petitioners in terms of the recommendations, proposals made by the university from time to time. But such service rendered by each of the petitioners after 10 years of their initial appointment shall count for the purpose of determination.
In fact, our cases when previously were,
Prayer,
Don't understand this as a direction for regularization.
no, my lord, it's very clear, my lord. The state government shall consider the proposal. We are
Yes.
considering issue and deed orders has been passed.
Please read the entire
Yes, ma'am.
sentence, please. Don't stop midway. The state government
The state
shall
government shall consider the proposal of the university sent on 12/9/2019 or any other proposal recommendation sent here to on 12/9/2019 and pass appropriate orders in accordance with law,
please read.
next,
bearing in mind the observation made in course of the order.
Have you done so? If you don't do so, that amounts to sheer, clear contempt of the directions of this court. unless you had obtained an order of stay or some kind of a modification of the order in the meanwhile. You did not. There is no such order in the writ appeal.
No state.
In
State,
fact,
state not.
In fact, state is in appeal here.
We have filed an appeal.
This is contempt, clear contempt.
We have issued, to that effect, we have passed an order, my lord.
You were not asked to pass any order,
After consideration,
not given the liberty to pass any order.
But-
You were given the liberty to pass an order in the directions.
shall consider the proposal that it means.
Counsel. I think this is plain English.
Please, ma'am.
P4 and
The
5.
university shall not shirk its responsibility of considering the cases of the petitioners for regularization of their services in the event the state government would leave it to the discretion of the university. In the event the orders of regularization are passed by the university, petitioners shall not be entitled to arrears of salary, but would become entitled to count their services after completion of 10 years. Therefore, the manner in which it should be considered is clearly stated in the order.
It may be posted next week, my lord. I have to check specific instruction from
Next
the
week,
department.
What will happen? You've already passed these orders.
Then
Let
they
me
say
take
we have
further
to
instructions.
challenge it.
Contempt.
Let me take
Lords,
further
may
instruction from the
kindly see-
department, my lord.
In fact, university, my lords, time and again, my lords are recommending for regularization of service. State says they don't have the financial capacity to pay us. That's
Let-
That is taken care of.
That's the only thing what they're saying.
Totally taken care of. You're paying them wages.
Please.
You have to pay them wages.
Please, my lord.
You cannot, this exercise is exactly what.
Let me take further instruction to that effect, my lord. What has happened, the present scenario.
That you are doing is exactly what Uma Devi said should not be done.
Please,
Backdoor appointments you make.
on the
It is not them. They don't come and squat on your chairs. You make the backdoor appointments. You make them work for 20 years at a stretch. And then you say Uma Devi. It cannot be. You cannot take advantage of that. What prevents you from making proper appointments? Are these after making after notifications? Well, if not, why not? What prevents the university from making appointments after due notification? You do this and then you say that they are not entitled to anything.
Okay.
This is what Uma Devi said you should not do. And even after 2006, you continue doing it. And then you say, whenever it is called to question, answer is Uma Devi. What is the
Shripal.
judgment justice?
Shripal.
Vikramnath
Shripal.
Jaggo.
Shripal.
After Jaggo, Shripal 5 days back. That they cannot rely on Uma Devi as a weapon to.
Let me see, my lord. That-
My lords, even the plea of financial burden has been rejected by the learned single judge. You would say it's irrelevant. Irrelevant plea of financial burden cannot be taken by them.
We'll argue on the writ appeal, my lord. If your objections are there, we'll comply with that and we'll argue on the writ appeal, my lord.
First, purge yourself of the contempt. Then we can consider the.
Next week, my lord.
As of now, without the appeal being admitted, without any interim order in the writ appeal, you're passing orders against the order of the learned single judge. Please purge yourself of the contempt. If you tell us that it will be considered in accordance with the direction of the learned single judge, then we'll consider. Not
Yes.
otherwise.
Next week, my lord. Let me take. Speak with. Next week,
Similar endorsement was issued on 1/2/2016. It is akin,
Identical.
not the
Almost.
present
You haven't read it
endorsement.
fully.
Those are cost.
Not that
Those
was
are the what has been quashed.
that is the subject matter before the learned single judge. But the Honorable Learned Single Judge has quashed the order dated 1/2/2016 and directed to consider our case. Lord, in the light of recommendation of Lord University, Lord University has recommended twice to consider our case. It was a composite proposal.
There are posts, you're fully qualified,
There are posts, my lord. There are posts. We hold the qualification,
found by the learned single judge.
Yes.
but only the difficulty is, my lord, before appointment, it was not notified. That is the only, my lord, fact which may go against us. But, Lord,
Has
for
to be notified. There is no doubt there. But who has to notify? The employees themselves cannot notify posts.
That's it.
So you don't notify. You make these appointments. Then you let them continue for decades together. And then you say, Uma Devi. Uma Devi said you can't do this. So when did Uma Devi say that? Uma Devi said that in 2006. At least thereafter notify. These persons who were working could have got probably got an opportunity at least to participate in this election. Now, after 20 years, you're saying Uma Devi just to throw them out. And now what will you do? Further said, you will engage persons from the open market in some modus operandi or the other. What is this? We'll give you a week's time, but tell us that this order is being recalled and a proper consideration as directed by the learned civil judge is being done. If that is done, we'll hold our hands for the time being. Otherwise, we'll take action for contempt. Please inform the concerned person. This is clear contempt. When there is no order in your appeal, this is clear contempt as of now. Yes, learned government advocate is given a week's time to get specific instructions as to whether the directions stand complied with, or to argue the appeal on merits on that day. Whatever you have to say, you can place before us, we'll consider. Yes.
19th February.
Sure, 50 for R3. What is the matter? What is this about? For the assistant engineer. Election duty, polling officer. Building in violation of sanction plan. 10/8/15. Complaint is on 10/8/15. Provisional notice issued on 20/10/15. Final order on 5/11/15. Karnataka Appellate Tribunal, final order stayed. Yes. So not
321 order.
So not final order under 321 is. Yes. Final order stayed by the KAT. Is that so?
Matter requires some consideration. Your Lordship may have it tomorrow or day after. I will.
Have it
Or
yes. Next week?
very well, ma'am. Anyway, my learned friend has interim order.
Yes. List.
Grateful, ma'am.
Yes, please get ready. If there are any objections or synopsis, etc., please place it on record.
Very well, ma'am.
19th February.
19th.
Grateful.
Yes, intermodal shall remain.
Past our matter. December 5. Sri Joshua Hudson Samuel.
Not
Yes.
use the notification as directed by this honorable court.
There is no we'll have to assume that there is no notification.
I think so. Because before the learned single judge also they have not produced.
Can we say that other than this area, that area? Notification of alignment.
Absolutely.
Training process and what extent of course. I do high-handed.
This should be. It must be there, right? Must be there. It must be.
My lord, this project is was commissioned in the year 2019. Project commissioned and energized also. They have drawn the lines also. 1 rupee compensation they have not paid. Mine is a residentially.
If as a matter of fact, there is a notification and an alignment, you are entitled only for compensation for the area on which the alignment passes.
No, that is
all.
exactly.
That is the statute.
I am entitled for full compensation.
How?
The exposition of law and proposition of law support my contention. Kindly, the two provisions.
If as a matter of fact, there is a notification, then the act is clear. It is because they could not produce a notification that the
My lord.
learned single judge went on to consider
My
the
lord,
effect, etc.
the consideration which will have to be taken into account is not only the right of way or user way. The consideration which will have to be taken into account is the diminution in value, health hazard. No, I'm supported by.
All that, if there is no statutory provision.
There is a
If as a
statutory,
matter of fact, there is a statutory provision,
there is a statutory provision to pay full compensation.
where is the provision?
My lord, two provisions, each from two different statutes provide, which govern the subject matter. Section 67 and 68 of the Electricity Act 2003 and section 10 and section 16 of Indian Telegraph Act 1885. First, I'll take up section 10D. 10D of Indian Telegraph Act. Kindly look into what section 10D contemplates.
Procedure may be there. Yes.
Section 10D. I'll read out only the relevant portion. 10D. In the power for telegraph authorities to place and maintain telegraph lines and posts. In the exercise of powers conferred by this section, the telegraph authority shall do as little as damage as possible when it has exercised those powers in respect of any property other than the referred to in class C, shall pay full compensation to all persons interested for any damage sustained by them by reason of the exercise of those powers.
10(1)A says the telegraph authority shall not exercise powers conferred under section except for the purpose of a telegraph established or maintained by central government. 10B says central government shall not acquire any right other than the right of user only in the property under, over, along, across, or upon which the telegraph authority places any telegraph line or post. Except as hereinafter provided, telegraph authority shall not exercise those powers in respect of any property vested in or under the control of management of any local authority without the permission of that authority. In the exercise of the powers conferred, the telegraph authority shall do as little damage as possible. And when it has exercised those powers in respect of any property other than those referred in clause C, shall pay full compensation to all persons interested for any damage sustained by them by reason of the exercise of those powers. Even there, it is only in respect of the, yes, only in respect of the, no.
My lord. Yes,
Correct.
how to ascertain the damage caused to you?
1 rupee they have not paid. My lord,
How to ascertain the damage caused to you?
they have to determine the compensation. Under section 16(3) of the Telegraph Act, say under section 16, they have to determine the compensation.
If in the exercise of powers mentioned in subsection 10, in section 10, in respect of property referred to in clause D of that section, is resisted or obstructed, district magistrate may in his discretion order that the telegraph authority. This is normal broiler lines. This is not like high tension lines. If after making an order under such a person resists the exercise of powers, dispute, etc., determination. Yes. That is only whether.
If the compensation is determined by them, if I am not aggrieved by the compensation, then I have a recourse under section 16(3). Compensation is not determined. They notify the land in the name of previous owner. They don't scrutinize the documents. Very haphazardly they have done it, very carelessly. A clear case of abuse of eminent domain.
A theory of eminent domain is there.
Section 63
67 and 68 of the Electricity Act.
This opening of streets, railways. Overhead
Is
lines is
expected,
68. Who appears for the appellant in this matter? Power Grid Corporation.
One 55. By the time they did the survey, I had already taken the plan approval for our residential layout.
That exactly is the problem.
No.
If they produce a notification, this is what, when the notification is issued. If they have not issued notification, that is the end of the matter.
Kindly see annexure F, my lord, for a moment. When they drew the line, I protested by writing a letter by the annexure E. In reply to my letter, they have written a letter, annexure F.
Hmm.
Second paragraph. The revenue survey works at survey number 47, 14/7, 14/8 for Timsandra village, Kasaba, Hobli in Anekal Taluk of Bangalore urban district was completed by government surveyor and sketches for those two surveys numbers were submitted to Power Grid with duly signed by 6 RI and ADLR on 4/4/2017. My plan approval is dated 6/4/2016.
74. Hmm.
What is your prayer before single judge?
Praise to pay full compensation.
Read that.
For
What?
No, I had amended the writ petition later. Amended petition is also annexed with this.
Hmm.
And it is amended, show us the amended.
Pardon?
Amended petition show. This page.
Amended it's at 211 to 220, page number 211 to 220. Prayer is at 220, 218 to 220, 219.
Showing 21 guntas, 1 acre, 12 guntas. That is 1 acre 33. Then, as an alternate remedy, pay full compensation entire extent of approved residential layout owned by the petitioner.
What is the pleading to that effect to show that entire 5 acre is covered?
It is the actual line drawn is shown at annexure L, my lord, 138, page number 138. This covers 2 survey number. I am the owner of survey number 16/1, 16/4, 16/6, 14/7, 14/8.
You are owner of 16/1.
16/1, 16/4, 16/6, 14/7, 14/8.
This one 16/3 you are not the owner.
16/7 I am not the owner. From top down.
What is the extent here in 16/1?
16 bar is 1 acre 3 guntas.
1 acre 3 acre line has not gone in that.
But my
Actually.
actually yes, factually speaking is not gone. It has gone.
What is the extent? 16/4?
16/4 is 1 acre 2 guntas.
Line is not round.
No, no, yes.
Now 16/6, what is the extent?
16/6 is 1 acre 9 guntas.
What is the extent of line drawn you were in that survey number 16/6?
14/7 is
16/6.
16/6 is 1 acre 9 guntas.
Extent. In that, what is the extent of coverage of this?
Coverage is given in here. Page number 202. Annexure 5, R5.
English version is there at page number 202. 202. At serial number 55, 56 and 58. Two not two. Page number 202, serial number 55, 56 and 58.
Is not mentioned here.
Extent is from the right third column. Third column. See, 55 is 6 gunta, 6.07 gunta.
Line, corridor, bus.
I'll read out. Serial number 55. Previous owner name is Revanna. Timsandra. Survey number 14/7. Total extent is 16, 1 acre, 16.5 gunta. Again 16.5 gunta. 1,70,000, that is the compensation, and total compensation 6 guntas, 6.07 gunta is the acquired land as a right of. That column is the land acquired for right of way. In 56 is 31.72. In 58, it is 5.
2017 5 SCC, which is the judgment? Have the judgments been placed on record? 2017 5 SCC, you have relied on.
Yes, my lord.
Where is
In state, kindly turn to page 39.
Where is the judgment comes? 17 5 SCC 143. On due approval of the above, check survey is done. Who approves it? We are referring to your memo.
That's, I'm just requesting, senior will be here, but he's on his legs in court hall number 26. He will come and address arguments.
Among the various judgments relied by the learned single judge, 2 judgments are squarely on this subject. Your lordship would find it at page number 53, in page number 29. The executive engineer KPTCL, Chitradurga and another versus Dodaka. In other cases, Kerala State Electricity Board was Livisha.
No, if it is my land is, just for understanding, if my land is 10 acre, side of the land line goes for entire 10 acre compensation.
If the value of the land is if it diminishes exponentially, then full compensation will have to be paid. Kindly see the kind of the way they have acquired the land.
It also does not, full compensation means.
My lord, I have-
Absolutely.
Not for the day.
Only to the extent of 7 guntas and 31 guntas, to the extent where it is affected. He cannot say 5 acres is affected, and kindly see the order of the learned single judge.
It is an ad hoc compensation, giving him the liberty under section 16(3). Kindly see the conclusion. There cannot be an ad hoc.
No, for a moment, kindly see annexure J for a moment. I had taken precaution before buying this property, whether there is any high tension wire being laid over the land. Annexure J. Page number 136.
What is the date?
8/5/2015.
Lord, his
I
name-
bought this property on 9/7/2015. Before that, I had made a complaint. What complaints they have done? They have not scrutinized the paper. They did not even check who is the owner of the property. They did not even check the EC also. It is a residentially converted land. And
They are purchasing this land or something.
It's only the
It is
user
only a
right.
line going over
It's
it.
only user right.
but when
User
you have
right
done-
in respect of the line corridor.
So how do you exercise this right?
This right is exercised under section 10(D) of the 10(C) and D of the Telegraph Act. My petition-
Even high tension is under 10.
Yes,
CN.
then, because I have a user right, I don't claim any ownership. They can still cultivate the land. There can be buildings which are constructed outside the line corridor. His whole case is that he's got around about 5.5 acres of land. And this passes only through a small corridor. To the extent of 46 meters on both sides, he need not put up any construction. Otherwise,
He cannot put up any construction.
he can't put up any construction.
Okay.
Well, kindly see.
Apart from that, he can
Anywhere.
put up constructions in the rest of
Completely,
his.
rest of
property.
it.
Now, what is
Therefore, as far as you are concerned, this approval has to come from whom? The memo says that it was duly approved. Who approves the alignment?
The alignment prior to 2013. In 2013, the Ministry of Power issued a notification stating that
Yes.
all these particular, wherever the lines are drawn, there should be a public notice.
Correct.
Public notice,
That's exactly
2013, 2013.
Hmm.
This whole project was conceived in the year 2010. 2012, the line corridor was done. And the alignments had been completed by 2012 itself. The villages through which it will pass was already completed in 2012, much before the 2013 notification. My ladyship would also, and my lords would also see, you had asked me to find out what is the process. I have the process. I'll place it before the court. And also the notification. Why I'm trying to say this is, in so far as the lines which run on these lands, many farmers cultivate. We pay them crop compensation. We pay them with regard to any trees which are cut. The horticultural department is taken into, they get the valuation from there. Accordingly, it is deposited. If there is a tower coming up, then to the extent of the land which is in the tower area, the Supreme Court guidelines we follow, 85% of the guideline value or the circle rate is given as compensation to them. In so far as a line corridor, if it is a high tension line which is going 26 meters or 43 meters on both sides, we give them compensation at the rate of 15%. That is the diminishing value of the land. Because they can't do anything. They can cultivate, but they can't put up a construction there.
So was this placed before the learned single judge? Was there an objection filed before the learned?
Yes. We had placed an objection before the learned single judge, wherein we had stated we had asserted all these submissions before the learned single.
2012 notification comprising the survey number is not furnished by them.
They say there is no such provision with regard to publishing of a notification. We also do, unless you show us what is the provision for the notification. That does not. appear to
Provision
be
is
a
only to-
provision.
I'm just placing that. I'm just placing the notification
Ah.
which came in. Just give me the notification.
Not only the notification, you've stated the steps you've taken.
Yes, I
Those
have a
steps also
small
to-
note. Yeah, I will give it. I'll give both. I've taken them because only last evening they had sent me these papers. I'll place it. In so far as our statement.
According to us, this should have been in the statement of objections placed.
Yes, I
before
have
the
stated so.
judge.
I'll just take this quote through the
That
statement.
should have been these materials, including your notification.
Yes.
The steps you've taken, those should
Yes.
have been before the learned single judge. This
Yes.
judgment
But
would
no,
not
but
have
the
come
learned
about.
single judge, no, all those things we had mentioned, we have asserted. I will show it from my statement of objections, which is already there on record. One 42. My ladyship might take page 142 of the paper. 142. That is where my statement of objections are.
Mm, mm, mm.
142. 142 of the paper. My statement of objection. At paragraph number 4, I have said what is the process which I read. Shall I just read the relevant paragraph?
Please.
The present petition has been filed to seek quashing, that I'll just leave it. The respondent, a Government of India enterprise under the aegis of Ministry of Powers, it is a corporation of nations incorporated as a government company under the provisions of the Companies Act. Power Grid Corporation is responsible for planning and coordination of interstate transmission system and also responsible for establishment and operation of the regional national grids to facilitate transfer of power. The respondent is empowered under the provisions of the Electricity Act to maintain transmission towers and to draw transmission lines under, over, along and across, in or upon any immovable property. The Government of India, in exercise of the powers conferred under Section 164 of the Electricity Act, has passed an order dated 24/3, vide Gazette of India number so and so, authorizing this respondent to exercise all powers vested in respect of the electrical lines and electrical plants established or maintained or is to be established or maintained for transmission of electricity or for the purpose of telephonic so and so. I produced a copy of the order also. Then subsequently, the respondent submits that Part 3 of the Indian Telegraph Act relates to the power to place telegraph lines and posts. Under Section 10, the Telegraph Authority may from time to time place and maintain telegraph lines under, over, along, across, post any immovable property, provided the central government shall not acquire any right other than the user only in the property in or upon which the Telegraph Authority places a telegraph line or post. Section 11 empowers the Telegraph Authority at any time for the purpose of examining, repairing, altering, so on and so forth. At paragraph 6, the respondent has been entrusted with the task of establishing the Salem Dharmapuri Somnahalli 400 kV quad line under the prior approval of the Government of India under Section 68 of the Electricity Act for strengthening the southern region with a Government of India Ministry of Powers letter number 2010. I produced it. Subsequent to the approval, the rural alignment was fixed in the year 2012 and tenders were called and awarded to the executing agencies. As per the revenue records, the land in survey number stood in the name of Revanna, Satish and Ramachandra. The prior approval of the government for the said transmission line is produced here with and marked as Annexure 2. It is submitted that pursuant to the sanction of the said transmission line, the petitioner corporation has carried out a detailed survey of the area to ascertain the most techno-economically feasible route for drawing up of the transmission line, taking into account various parameters, such as I've just listed out the parameters. The respondent submits after taking into account all these parameters, they have finalized the most techno-economical feasible line route, and accordingly, the project with a line length of 122 kilometers with 335 towers at a cost of 202 crores has been constructed, completed and commissioned, energized and dedicated to the nation on 30th of March 2019. This transmission line has vastly improved the power supply in the state of Karnataka and does not have any impact on human beings, animals, plants, etc., or on the geographical or ecological system beyond the statutory clearance norms provided by or under the Central Electricity Authority Regulations 2010. The transmission line passes through various villages from Dharmapuri to Somanahalli. The landowners have been adequately compensated for the tower footing area, corridor area, and for damage caused to crops and trees. The compensation is based on orders passed by the concerned deputy commissioners in line with the guidelines formulated by the Ministry of Power, Government of India, and published vide notification dated 15/10/2015. A copy of the notification also has been produced. The respondent submits in the course of execution of the transmission lines, the land in survey number.
This Deputy Commissioner has determined in this case?
Yes, has
Where is that-
determined.
Where is that order?
Yes,
Just. go on.
yes, I'll just. Sorry.
Not the right.
It is R5, which I have
183. Page 183.
183. I'm sorry, it is in the vernacular, but I've also had the English translation done at R5, page 191. The English translation.
For this survey number,
Sorry.
for his survey number.
Yes. No, it runs through the total extent wherever it is required. Yes.
But it has the survey number also.
Whatever villages come within the vicinity of the deputy commissioner or the jurisdiction, I should say.
It's 15% of the guidance value.
Yes,
15% is guidance value.
yes,
On that basis, next charity is the case. All
yes,
the-
correct. And furthermore, I called upon I can only go by, I cannot go into a investigation as to who's the owner. I can go on what the records are, revenue records which are available. After he had purchased it, he had not got changed the revenue records. I went by whose name the RTCs were standing. I called upon them to come forward and take the deposit. Kindly see the document which I have produced and which forms a part of the court records here. That is a letter which I had issued to them,
Sure, 129.
129. Thank you, sir.
Page.
129, which I already referred.
No. One.
Oh, that is to the writ petitioners themselves.
Yes. And there we have said
Hmm.
at that second paragraph, during execution of the project, one of the landowner has been informed to receive, as my ladyship
Hmm,
heard,
hmm.
to receive land compensation by submitting bank details and other relevant documents. However, he has not come forward to take the land and compensation. As per the revenue sketch and DC urban land compensation order, the land is in the name of the above named owners.
Hmm.
The name of Abhishek has not appeared anywhere, neither in the survey sketch nor in the DC urban order. And in the RTC, Abhishek developers never approached Power Grid for compensation payment during the construction of the Dharmapuri so and so, as landowners have not turned up to receive the compensation. The disbursement is still pending. I should just point out this factual mistake which the learned trial judge went on the premise as if I had paid the compensation. I had not paid because the matter was reserved. We were not able to, and only subsequently we got to know that this is what was.
Have you gone under section 16(3)?
No, I have.
Order.
16.3, they have to issue, determine the compensation.
With regard to the.
No, it is
property,
issued in the previous owner's name. And
Yes,
moreover,
when-
by the time they notified the land, I had converted, I had approved the layout for residential layout. 2017.
The 16(3).
The deputy commissioner-
16(3). No, not even before the deputy commissioner. What section 16(3)? I will just take the code through the Indian Telegraph Act. ಅದೇನಾಗಿದೆ ಅಲ್ಲಿ? And there are almost 4,000 cases pending in various district courts pertaining to enhancement of compensation. 16(3). If any dispute arises concerning the sufficiency of the compensation to be paid under section, because 1 and 2 will not apply. 1 is with regard to removal of obstruction. 2 will not apply. under section 10 clause D, it shall on application for that purpose by either of the disputing parties to the district judge within whose jurisdiction the property is situated to be determined by. So even the deputy commissioner who had fixed the compensation at the first instance, he will not be able to determine because his power is only in order to remove the obstruction and on our application to arrive at the fair value of the land. And that is what the order of the Supreme Court also says. The notification which we have produced also very clearly says that the Supreme Court, and this has been accepted also. Earlier too, my ladyship will also, in Livisha's case, that was one of the first orders which came to be passed. Subsequently, there were various high courts which took different views. Then the Supreme Court said, in order to put a rest this whole thing, let there be guidelines framed. Now, in certain cases, in respect of certain lands which are closer to the urban area, we are giving them 4 times the guideline value compensation. Because we don't want them to lose out. So, for some reason, if he is able to establish and place evidence before the district judge under section 16(3), and if he comes to the conclusion that the compensation which we have already assessed pursuant to what the DC has done is insufficient, he can claim. The only thing is he'll have to seek the leave of the court to say that I am the subsequent purchaser.
And produces documents.
Absolutely.
My lord, one submission, my lord.
Yes.
Under sections 16(3) will trigger only if they determine the compensation in my name, taking into account that the land is,
Please look at 16(4) also.
pardon,
16(4) as well.
16(4).
16(4).
If there is any dispute amongst
If any dispute arises to the person entitled to receive compensation or to proportions in which the persons interested.
Section 30. Section 30 of the land acquisition. Similar provision is there. So you can, now the khatedar or the RTC holder is not claiming the compensation. He's done nothing.
Let them reissue fresh notification under 16.
So we'll say that the time you have spent here, probably, is there a statutory time limit for approaching under 16(3)?
Limitation act, 3 years will lag. But however,
Article 137.
We can probably
have
say
no
that
issue.
because of this, this direction which has been issued by the learned civil judge.
And the,
I have no objection. Let him go, even let the court grant him
and
the
the
leave. I have no-
yardstick taken for determine the compensation is agricultural land. By the time.
All that you
everything,
can produce.
everything.
If you have actually gotten a change of the nature of the land, all that can be produced before the district court. If it is not agricultural land, and if you are entitled to further compensation, you would be entitled to it.
Mysore Calicut line, it passes through Pur. Lot of plantations, including Tata plantation, has been affected.
No.
They have claimed compensation of 12 crores. It's a plantation.
My lord,
No,
I-
it's not.
I-
What he says is, during this process, he purchases the land, he converts it and makes it residential land. Therefore, by the time the compensation is fixed, it is as a matter of fact, those are matters for the reference court to consider. The
This
district court to consider.
notification for acquisition of high tension project should have been widely notified.
Should have
in-
been.
That I agree.
And public hearing should have taken
Court
place.
officer, court officer.
Absolutely.
Nothing has been done. Whole process is botched up.
Probably what happens is, these aspects are done so that on
No, this-
paper, if
this-
we
this-
call for paper will be available.
No, nothing has
But
been done, my
whether
lord.
whether the actual owners of the property are aware whether this has happened.
No,
or
because
somebody-
yes, they have. I'll just
Where is
explain
the
why.
paper notification, my
Just
lord?
1 minute, sir. I'll just clarify. Just one. Why I will say this is, when in 2012, when we are drawing up the lines, we go before the deputy commissioner collector. We tell him that the line is passing through all these lands. Please determine what is the compensation. He gets in touch with the Tahsildar. Yes, he issues notice. He gets in touch with the Tahsildar. He gets in touch with the horticultural department. He collates all these material. Once he collates these materials, Based on that, he arrives at, because that is what 2015 notification of the power, Ministry of Power also says. It will be, they will be guided by the Deputy Commissioner, Collector or Tahsildar, whatever the case may be.
That is not the case. For the compensation.
Compensation, that's what.
Before laying the line, how I'll come
That
to
is,
that.
that is the point.
Laid in mind.
Before, when the proposal is being approved, there must be wide publicity.
That is
as
after
to where-
2013.
And I have taken endorsement also from Tahsildar before buying the land.
But anyway, if he can file an application under 16(3) and establish that he is entitled for more compensation.
Nothing there is there to establish. He is bound to pay compensation.
I will pay. I will pay. If the court determines, I will deposit immediately.
Yes, yes. We
Then
can.
have land also. Town line.
What is the judgments?
One more factor I would like to highlight here. Nobody would like to purchase any sites there where the high tension wire is hanging. Nobody would like to purchase any sites. So the whole residential layout will be abandoned. It will have to be dismantled.
Where if
It's a
close to
440
one-
kV high tension wire.
Yes.
Corridor is
What-
46.
On one part of the property,
Kindly
it
see
is
the photograph, my lord.
large
Kindly see the
extent.
photograph. Kindly see the
The
photograph.
personal photograph, it is where it passes. It is at one
It's a-
end of the property.
It's a pylon.
Sketch is there, the sketch I print.
It's only a matter of, those are matters which you can raise before the district court for higher, for all your contentions we
Yes,
leave
yes.
open to be decided.
With that liberty.
Yes.
So, we'll just to clarify this, otherwise reserve and then. Okay.
Yes.
They're just saying that, we should go there. Determination by the single
Yes,
judge
yes.
not be correct.
Yes, with full liberty to agitate.
Absolute.
That's
all
whatever
contention.
is relevant.
And
To the
time,
extent of compensation.
absolute, time also.
Full land or the full compensation, double compensation, we don't know.
No, but it cannot be, it cannot be.
I may be protected under section 14 of the,
Whatever, you can raise all your contentions there
Permission.
in terms of what is permissible.
definitely there is diminution of value.
No, I
Absolute.
concede on that aspect. If there is a
Absolute.
line corridor, there will be diminution of land value and I am.
And there is
liable
health
to
hazard also.
compensate him at the end
Health
of the
hazard
day.
also. It's a proven thing that it causes cancer.
No, I'm sorry. I'm sorry.
I can give enough material, scientific
Then
material.
we all have to have only lanterns and home, not electricity.
Yes,
No, it creates electric field which is injurious to health.
everything we do in the present time. The mobile phones that we are using, the computers that we are using, the air conditioners that we are using. Is
Even our-
detrimental. We are all suffering the
No.
difficulties.
My only submission, that is a government of India enterprise, the threshold is higher. Threshold of legality is higher.
Absolutely. We agree, which is why in 2013 it has been ordered that it has to be published in newspapers, without which it cannot be done. We see, which is why we thought that that would be there. We were not aware that pre
It's an old
2013.
line.
it did.
2010 line.
No, you cannot take citizens
Because
for granted.
after 2013, we've seen that, no, I don't know whether it is after 2013 subject. We've seen that in newspapers, we have these
Yes.
detailed, the path through which these lines are being
Yes.
drawn. We have
Yes.
We are also putting it in the Tahsildar's office.
Tahsildar, who will go there?
No, I'm just saying,
disease.
no, over and above that, so that people, villages will get to know.
No, they have not provided any,
Notifications, people will
Yes,
see.
yes,
no, they have not produced any,
Have that survey numbers, all the
yes,
details.
yes.
they have not produced anything to show that they have notified it in the newspaper.
No,
Public hearing was held. Nothing was presented before this court.
Recent decision you have.
I was just, the judgment of the Supreme Court and Abhishek Developers. I'm sorry, Century Textiles. I'll place.
After this.
it cannot be Abhishek developers. Abhishek developers is the, it cannot be Abhishek developers. Abhishek developers is the competition. Yes,
Shall I just make a memo and place all these judgments?
please.
And I'll even give the paragraph numbers, so that it'll enable the court not only in this matter and other matters.
Yes.
Today only.
Today, I'll give it to you. By the afternoon, I'll give it.
Yes, reserved for judgment.
Great. Good. I'm
Number
sorry, my mistake. I'm
13.
not here at first call. I was.
Number 13. Please, Sunil Rao.
It's the matter pertains to. Peak matrix may not spend within the.
Medical PG in service quota,
Please,
eligibility.
in-service quota. Now, Manoj, by virtue of an executive order, Manoj, the eligibility, Manoj, which stood as, Manoj, the eligibility, Manoj, was that a particular candidate had to complete X many number of years within the quota in service based on 31/3/2024, 31st of each month, 31st of March of every year. Now, Manoj, this is the rule which has been formulated under the Capitation Fee Act. Now, Manoj, this rule is sought to be altered by virtue of an executive circular. Thereby, what they do, Manoj, is they increase the threshold date by 4 months. And Manoj, various other candidates, Manoj, who could be junior to me, Manoj, they get into the.
When?
Manoj, this happens in 2024, Manoj. This happens on 2024, Annexure 8.
And when do you get your eligibility?
Manoj, my eligibility is 31/3. Manoj, I'll just point out the rules.
After 4th of March.
Your eligibility is 15/1/25.
50, absolutely, Manoj, 50. But I'll just point out how the rules operate for one moment. Your Lordship are perfectly right. Now, my Lordship will see the rules which are here at running page 44. I'll take my Lordship just straight away to my Lordship 49 for one moment. 3 minutes is the.
Yes.
No,
Reference list.
3 minutes is the enabling provision for a candidate, not in-service candidate, to take up a entrance test. Now, minutes there too, there is a threshold in sub-rule 2 for a moment.
In-service candidates.
Yes, minutes. This is only with
Who have
respect to in-service
completed
candidate.
5 years of regular service,
Yes, minutes.
including successfully.
And the threshold date minutes will be computed as on 31/3. Now, minutes, rule 10 thereafter. Rule 10 minutes is to go in for counseling. Now, minutes, my applications are in.
5 years of regular service,
Yes,
including successful completion of probation.
And your Lordship will see when that 5 years will be reckoned. Your Lordship will have to go to rule 10 at page 56. Page 56. 5 years not has now been made to 3 years. It's all right. But there is a substitution. I'm just pointing out the date. What is relevant is this.
CGF is election. CGF, no service candidate.
I hope your Lordship come down to 56 for one moment.
5 years of regular employment
Please.
in service, including successful completion of probationary service, as on 31st March.
March
which
20.
The entrance test is.
The
held.
cutoff date is 31st. Now, by virtue of the impugned executive order, Manoj, they change the rule. Manoj, by virtue of executive circular, Manoj, they subsume the rule. They say it shall not be 31/3. They say, Manoj, it shall be 31/7. What happens by this, Manoj, says, Manoj, there will be a flurry of candidates who are junior to me, Manoj, who would be eligible for the next year. Stricto sensu. They come in. And Manoj, what happens, Manoj, says the quota is filled up with so many other people, Manoj, because we are in service people, Manoj. There is a small amount of quota which is created. Reason being, Manoj.
Not so small. It is 25%.
Yes, Manoj.
20%.
20%. And
Quite a big
yes, Manoj.
quota.
The reason, Manoj, says, the reason is I'll be performing my duty elsewhere, Manoj. And within a channel, Manoj, I'll have to apply for these seats. And now, Manoj, there is a fixed quota every year. Now, what happens, Manoj, is if there is a floodgates which is open, Manoj, juniors to me, Manoj, who have an advantage, come over. Manoj, there is definitely.
There are 2 aspects to
Yes,
it.
Manoj, yes. There is one aspect.
One
yes.
aspect is that the in-service quota stands decategorized even before you.
I will not be bothered about that. I make
in
my
your
submission
entity.
clear about that. I will not be bothered about that. Now,
Why would you not be bothered?
No, I'll just point out why. No, Manoj, I think there are a couple of number of seats which, Manoj, subsequent to admission of the quota students, Manoj, they'll be decategorized and put over into the general category. So that counseling is now still going on. Now, Manoj, what has happened, Manoj says. Now, what is precisely happening, Manoj says. Now, there has been a revision with respect to the marks list which your Lordship pointed out. That is the eligibility, what your Lordship said. You become eligible vis-a-vis with effect from.
Now you have to compete with persons.
In the general quota is what they would say.
Yes, in the general quota.
This is what they would say.
Yes.
Because the reason why that is being done is because of this executive circular. Now, your lordship may kindly see, if not for this circular in force, if this circular is not there, if this circular is not there, then ipso facto, I am eligible, and by virtue, I'll just point out why, I'll just point out why. Your lordship will see there are 58 respondents. Among those 58 respondents, I can point out, less than 30 passed this benchmark of 31/3/2020. If more than that, and your lordship will see, among these 30 or 35 students, merit will then kick in and say, all right, he is eligible in terms of the marks list, which has been published. Now, what happens is,
If
yes,
merit as initially notified
yes,
was the criteria,
yes,
you are nowhere in the,
I would have missed by a,
nowhere in the reckoning.
I would have missed by a single mark.
Whatever that
Yes,
is,
sir,
you are
I would have missed
nowhere
by
in
a
the
single
reckoning.
mark.
It's only on 15/1/20
Re-revision.
that the notification
Correct,
lowers the percentage
Correct,
and you become eligible.
yes, I have become
But
eligible.
once you become eligible,
Yes,
can you raise all these contentions with regard to the
only
eligibility, which
for-
is already notified in 2024?
I'll just, your lordships are asking me, let me just clarify, so that I understand the question properly and revert back with a proper answer. No, your lordship's question is very limited to this saying, you were not eligible as on the day when this executive order came.
Absolutely.
Now, that is one part of the
Mm.
issue. Second part of the issue is, there is a counseling which went on, possibly in November, December, starting in November, ending somewhere by the end of December. Even at that point, you were not eligible. Now, post facto, that is
There's
after
another aspect
January.
to it.
Yes,
There is another aspect to
yes,
it. By the time you come in,
yes,
by the lowering, there's no longer the quota available. It's all general seats.
no, the quota is still available. I just wanted to point out.
It has gone.
Quota is gone.
There's a
to
decategorization.
Yes, I'll just point out. I'll just point.
Yes,
Your lordship's
yes.
happy.
We've just pronounced a judgment today.
Yes, I am.
Hmm.
I'm aware.
Hmm.
I am aware of the fact that it pertained to where people came and said, I need that category, non-category seats. Your lordship said, once it is thrown open into general category, the water flows out and it cannot come back. The die has been cast. I understand. That is not my petition, which is what I wanted to point out. That is not my petition. That is not my petition. My petition, is against the persons, who inter alia claim this quota. Who inter alia claim this quota. Now, if your lordship say 31/3/24, the benchmark cannot be altered, I am in. If your lordships hold, no, by virtue of this executive circular, which violates the rule.
We're not saying that. We're saying
but-
that you who
Yes,
get an eligibility to be considered in the selection only by the lowering of the standards on 15/1/25 cannot challenge the fixation or whatever, the date fixed much in advance. This is on 31/7/2024. When does the brochure come out?
Exactly, this is the point what your lordships are asking me.
Yes.
The list of dates is this. The notification is dated 16/4/24. The applications are filed on 6/5/24. Then the last date for filing of these applications is somewhere in the end of this month of May. The date, I don't have it exactly, but I'm told it is the end of this May. Then the applications are scrutinized in the month of June. And after that, the rules are fixed. I'm just pointing out, this is fixed for all of us. Now we believe, the threshold date is 31/3/2024, which all of us are bound by it. You
Were not in the picture.
I was.
When?
As on, my application is there as on 16/4/24.
16?
My application is there on 6/5/2024. 6/5/2024.
Cannot be an application on 6/5/24. There cannot be an application
Yes.
by you on 6/5/2024 because you don't have the eligibility. It's only when the eligibility gets reduced
No, but
on
it's-
15/1/2025 that your application becomes competent.
Your lordships
At
are
that
saying, what's the
time.
date of filing of the application? My date of filing of the application is 6/5/24.
That is, anybody can file the
Yes,
application.
no.
Cannot
Why
be
I
considered
pointed
because
that,
you don't
why I pointed that, says, the rules of the game theory. Your lordships are aware, the rules of the game theory, cannot be my lords, it cannot be loosened out.
If that
Once,
is
my
so,
lords, the final date.
that is so.
Yes, my lords.
you
It
cannot
applies to me,
participate-
it applies to
you cannot
everybody.
participate in this selection at all. Because the rules of the game as fixed, where that the percentile would have to be 40%, 50%.
50.
For the percentile
Please, my
was fixed in the selection would hold against you. How can the rules of the game be changed?
It doesn't.
How
go
can,
to-
how can it be
Which is
reduced?
why I am pointing out, not, which is why I am pointing out. For one moment, I am not against, not, let me not obfuscate my case with the general category case. No, I'm not with that. I'm not against that. I'm not for that for a moment. I am different. I'm just pointing out. I am only with respect to the in-service quota only. And not who have been selected within the in-service quota only. No more, no less. No more, no less. Not-
That be so.
Yes,
In
ma'am.
service quota ends with the second round.
In
Second,
service, there is no second round, which is the relief what we have sought.
with the first round, the in-service quota of the persons who were eligible ends.
Now, what has
In the
happened?
second round, what has happened is there is a decategorization.
Notice, I only wanted to point out this. Notice, by virtue, once the applications are filed, there is an executive order which has been passed. Notice, it says, it relaxes the rule.
Our answer is only this. The
I also
relaxation,
know that there is a conundrum which has
Relaxation.
been created.
the relaxation by which you become eligible to apply is also a changing of the rules of the game while the game is on, because the required number of people to fill up the seats are not available. If what you're saying is accepted, there could be no relaxation at all.
I would only
And you
point
would
out this,
also,
Manoj. The fixation of the eligibility merit mark, Manoj, would always date back. This is the law, Manoj. I think I'll have to convince your lordships only on that aspect. Only on that aspect. Because, Manoj,
we can require them to get instructions in the manual.
Similar matters are posted on 21-2.
there is one
Yeah,
issue,
cannot-
Manoj, I would, no problem. Your lordships are deferring it, I have no issues.
So,
I'm only requesting this. I'm
Hmm.
only requesting this, Manoj.
Hmm.
Your lordships want to have it on a particular date, not, I'm just pointing, not 21st.
Hmm.
I'll have to, there is a family plan that I might have to go to Prayagraj.
Next,
That is why, no, not after.
we'll hear the other matters on 21st and have it on the
May I
day
request this,
thereafter.
Manoj, may I request this for one moment? Is there a possibility that your lordships could have it on 17th? I'll take my only chance on 17th. And if your lordships are still on the same page, Manoj, I don't think I'll be able to change. 17th only.
There are about 6 petitions which are
No,
listed on.
Manoj, those 6 petitions are different. I'm
No,
told they are
it's the same.
different. 17th. By that point of time, Manoj, after 21st, Manoj, everything will be infructuous.
And my lord, one more
20th,
submission I
Manoj,
want to
is
make.
a-
I want to make one submission, my lord. The stray vacancy round dates are not announced.
19th is the last.
It's not announced as yet
Hmm.
because everything is postponed because of the All India quota postponement.
Okay.
Lord, also I contacted the KE and they said that about 615 seats are remaining as of now, as on today.
Then-
More cancellations may
I
happen,
think, if they can offer
the-
the quota students.
but the
Manoj,
quota
1
is
or
not
2, 3.
available.
1, 2, 3.
My lord, in fact, to what
Exactly,
Any of
you-
these exercises, approach them. If
exactly, Manoj.
it is
And-
made available, we will not.
Yes,
stand in
Manoj,
the
I
way.
but in
agree, I
fact,
agree.
List on 21st
Manoj,
and
may I request one thing, Manoj, may I request? Could it be on 17th? 17th, Manoj. 17th.
Sorry, please.
Manoj,
Yes.
my only request, Manoj, is 17th, Manoj, I may not be, 21st, I may not be in station. This is my only request. Could I
I'll
have,
leave
could
it
your
to-
lordship have it on 17th? 17th, and then, Manoj, your lordship may post it very well on 21st. It's only for that alternative.
I'm with my lords.
17th.
All right, please.
1, 2, 3.
At least some alternative can be done.
Lord,
We cannot do it.
my lord,
They will
private
be-
parties are there.
Because
Private
this
parties are there.
conundrum has started because of a learned single judge's order.
NMC Ramesh.
NMC,
Without
KT,
taking the KE.
Mr. KT.
Why this conundrum has happened, not in this.
List on 17.
Yes.
Last but not the least, the conundrum has commenced because of a single judge's order, Manoj, who has possibly taken up the DB's roster and passed an order, Manoj, without the KEA being there. Your lordships are aware of that, I know that. This is,
Yes.
Manoj, this has led to this debacle.
Our register is sometime also like a KEA. The executive order, they amend the rule. So in today's order, you please say, ladyship has suggested government and KEA to look into that amendments. In every state's very clauses are there. It helps them reduce litigation.
when the brochure is clear, the
It's there.
students are helped, then they need not, and if there is anything that they have to complain about, they can complain at the stage of the release of the brochure itself, not wait till the last possible moment to raise the contention.
There's a lack of coordination between the authorities also.
That also,
I
that is
think your
what,
lordships have pointed that out. in
that
the
is what we
subsequent-
intend.
On my-
Yes, there.
My
there's a
other
correction.
submission is, my
corrections are-
lord, the executive order was passed. They've extended the cutoff date. But they've not challenged it then.
It's not
So
a
they're,
cutoff date.
they're
How
not,
can-
they're not eligible at that.
Well,
at
they
that
were not
point.
eligible at the time.
If they had come challenging,
Please, my lord.
you would say that they're not
My lord,
eligible.
but their eligibility starts from 5/1/2025. And even then, one round is over.
For unknown.
Said that, fixing the date.
The
is
marks
not-
for unknown.
What you require to do is not,
My lord, this is,
it has to be done with some kind of,
please, my lord, I understand.
some kind of coordination between the
Again, my lord, my submission would
NCC,
be,
the MCC and the KEA, so that the students will be helped.
my lord, from what I gather, this whole exercise is because they want to see how many seats remain vacant after the second round. And then they
No
decategorize.
difficulty. Just do things so that nobody is left out in the process.
That's true, my lord, but now the percentile which is reduced.
And throwing open these seats so hastily into the general quota. I'm not saying it should not, because ultimately the
No,
seats should be filled up. Because they must call for at least some sort of a
Lord,
notice to the
this would
interested
be-
candidates.
Shall we
there.
tell you what is working in our mind?
Yes,
The difficulty with regard to this quota, even in service quota, is the earlier judgments of the apex court.
Correct.
On PG need. The apex court says there should be no quota and it must be all on merit.
correct.
And it is only in exceptional circumstances that some kind of quota can be considered in PG admissions. So therefore, it is the state government in its wisdom, which says that this is required because for the
States
state
are-
government,
Yes.
for the government to get postgraduate doctors. That is the purpose of the PG NEET quota. It is not some kind of a right to the in-service
Correct, sir.
candidates.
Otherwise,
It-
your leadership.
Otherwise, they would
that-
not be able to. You
It's
understand?
as simple as this. No PG doctor Manots would like to join a government service.
Correct, correct.
We are
This-
grooming doctors Manots in service, Manots who can continue with a higher degree also.
Which is why.
Very
the-
important.
Which is why the in-service quota has been permitted by the Supreme.
Exactly. Manots, and it's
Otherwise,
quite
failing
important.
which it would not have been permitted at all. Because the initial view of the apex court was that there should be no quota for PG NEET. It must be merit alone.
And
Then this is carved out so that government doctors don't lose out and government does not lose out.
correct. And
This is the
age is
proposition.
also, there is some issue, Manots, the age is also running out for these people.
Correct.
Now, Manots, if they are not able to make it within the age limit, Manots, then they lose that. Then they will just remain medical officers throughout their life.
Correct.
This is something, Manots, which the authorities as well, Manots, the courts may just look
Manots,
into it.
As far as we are concerned, it is not for us, it is for the authorities. And the authorities, as we understand things, are looking into the difficulties. They are trying to sort it out.
Lord,
But probably this lowering also, probably what happens is all of you might get.
Yes.
Lord,
There's a possibility. All in-service candidates who have made applications, probably, maybe barring the very last few, all of them may get in because of the numbers that. have
in
been
fact, for
released.
stray vacancy, if they reduce it to 0, I won't be surprised, then everybody will be eligible. But then after this confusion,
Can participate and on the basis
No,
of merit, everybody
There's
can.
Much of ifs and buts there. Age is running out. If
But-
not for these ages, Manots, I don't think,
Understand, but then for us to say that this is how it should be
because
conducted
Manots, there are,
beyond,
this has happened, Manots, what has happened, Manots,
You know.
exceptionally, they have made a circular.
absolutely, what happens
Exceptionally,
is
they have made a circular.
whenever there is any direction issued by the apex court also, is under 142,
Yes, it is
not under
purely,
that is the
no, my
difficulty.
lord, the reason why,
Have that kind of, in these situations, we don't have that kind of power. If we do something, you've seen,
I'm not sure, Manots,
Well-
but there is one article, Manots, which your lordships can still get into it. 215, though not exactly 142 minutes. 215 minutes is quite sufficient for your lordships under the High Court. Which Manots, I don't think,
we'll tell you what the difficulty
Yes.
is.
It's just that
Different high courts issuing different directions. Suppose it is with regard to all India quota. There are conflicting directions. Those should not happen, which is why
No, I understand the
one
limitation.
forty-two is being
I understand the
expressed.
limitations of 215 because we cannot have a law for each state, especially when it is having a national.
If we are talking only about KEA, Court officer, please switch off. If it is only with regard to KEA we are speaking, then probably there is something to it. But it also overlaps. There are all India quota seats available. There is, when we are exercising this kind of.
I will just
jurisdiction-
make this one last, I'll just contact my friend. See if there is something which could be done only vis-a-vis the quota is concerned. If not, if I'm not wrong, there are 3-4 such aggrieved candidates, not more. The entire doctor.
They're anyway permitted to participate in the general round.
Participation in the general, I don't think.
Also, because of all this.
Apple and oranges cannot be the same nuts. People who dedicatedly study only for a PG
Now,
and there's people who work in a government hospital, spend X amount of hours and was on a government duty. I don't think they can compete in the same sense.
that is the only reason, because of all this confusion, Manoj, the government has decided to extend all the benefits of in-service candidates to these students also.
In fact, I am their
fees will be
their
paid.
citizen, Manoj, more so. They have to take care of that.
That is the reason, Manoj, their fees will be paid, their stipend will be paid, everything else will be on par with in-service candidate, but for the quota.
Yes, let's see.
17.
Great.
17.
Serve them.
Please serve
I'll
the.
do the.
Final hearing matters, number 37, P. Chinnappa.
Yes. You have your synopsis? Yes, please take us through your contentions.
The exhibit P1,
Hmm.
clearly at paragraph number 6 provides that paragraph number 6.
Just a moment, please. Paper book. P1.
P1, paragraph number 6. Page number 152. I'm referring to paper book with respect to cross objection.
Yes, cross objection 5. Hmm.
Page number 152.
Hmm.
Paragraph number 6 clearly states that all approval, consent and notices to be given under this present shall be in writing and save as are herein otherwise provided for, shall be signed by or on behalf of the lessor, and any notice given to the lessee shall be considered as duly served if the same shall have been delivered to or posted by registered post addressed to the lessees at the premises hereby demised.
Hmm.
Going by this, your lordship, plaintiff at several instances has stated that the option to purchase was conveyed to the defendants orally.
Hmm.
There was no written document with respect to that. And that is also forthcoming at page number 90 of the deposition of the other paper with your lordship. Page number 90.
Yes,
Page number 90.
90.
990
Hmm.
is the exercise of option was in writing or oral. He says orally.
Not already.
Where are you reading, counsel?
The consent.
This is from the main. This is from the main appeal.
Please,
Sir,
Counsel.
my apologies, sir.
It will be there in both, no? Please tell us where it is in this cross objection paper book.
You are ready? The deposition of PW. Position of PW1. Which page, Mr.?
My paper book is page number in 508, not it's page number 8.
It's not here.
There are 3 paper books. I also apologize.
Yes, 508.
Yes, you should make one.
Hmm. Hmm.
Exercise of option was in writing or in oral. He says it was in oral, it was orally.
Hmm.
But the exhibit B1 clearly states that it has to be in writing. If there is a consent or even if there is an option, everything has to be shown in writing, but nothing has been produced by the plaintiff. Coming to the reason for delay in execution of the sale, he says that he exercised the option in the year 1976, but nothing is forthcoming with respect to such an assertion in plain. Nothing has been said with respect to that in plain. Plain is absolutely silent about that. It is only in his evidence affidavit he states that yes, I exercised my option in the year 1976. And the reason provided in plain, he says the delay was caused because there was reasons best known to the defendants is what he says. Page number 17. The page number 7. Page number 7. On the top, exercise their option to purchase the scheduled property, though the defendant assured the plaintiff orally, as well as in writing that he would execute and register the sale in their favor. Paragraph number 5, your options. Page number 7 of the paper.
Though the defendant assured the plaintiff orally as well as in writing that he would execute and register the sale deed in their favor for reason best known to the defendant, he has been avoiding this.
Nothing, no explanation. But later, during this deposition, at page number 39, for the first time he contends that for non-receipt of ID clearance, he would not, the sale deed would not be executed. Page number 39, paragraph number 5. Paragraph 5. The defendant told me during the year 1974 that he cannot get ID clearance from the sale of the site to me, agreed to between us. Then the defendant suggested to me, to take the site on a long lease with an option to purchase, and I agreed for the same. And something similar has been again stated at page number 42 as well, your questions. Paragraph number 10. Page number 42, paragraph number 10. In the first week of February 1976, I told the defendant that I am exercising my option to purchase these scheduled premises, and the balance sale price will be paid on the date of registration. Again, this goes contrary to what has been stated in the plaint. In the plaint, he states that everything has already been paid at the time of.
Where does he state so?
Paragraph number 5. The plaint. That in exercise of the option reserved in favor of the plaintiffs, as per para 2J of the lease agreement dated 6th February 1975, the plaintiff paid the defendant a further amount of rupees 550,000 on various occasions which has been approached by the defendant. So this goes on to show that this was paid immediately after exercising the power. But here he states that the balance.
Where does it say that immediately on exercising? That in exercise of the option reserved in favor of the plaintiffs as per para 2J of the lease agreement, The plaintiffs paid the defendant a further amount of 50,000 on various occasions, which has been acknowledged by the defendant, and the plaintiff exercised their option to purchase the property from the defendant. Plaintiff have paid these rentals to the defendant regularly with default till they paid the balance sale consideration of 50,000 to the defendant and exercised their option to purchase. So the defendant assured the plaintiff orally as well as in writing that he would execute and register the sale deed in their favor. For reasons best known, he has been avoiding execution registration of the sale deed. All the same, plaintiff was always willing to perform his part of the agreement. Yes.
Here it states that to be paid, the remainder will be paid at the time of registration.
In the first week of February 1976, I told the defendant that I am exercising my option to purchase lease scheduled premises and balance sale price will be paid on the date of registration and requested the defendant to fix the date. Defendant told me as his building construction work is entangled in tax problem, it is not possible, etc. That as he will be in need of income, I must oblige him by paying whatever amount he needs, same shall be adjusted towards balance sale consideration. As decided by defendant, I paid. There's no contradiction. Yes, the checks issued by.
Takes the contention that execution of sale deed was delayed going to the issue pertaining to capital gains. Page number 46. Page number 46. Paragraph 8.
Yes.
I state that I was requesting the defendants repeatedly to execute the sale deed. The defendant was postponing to execute the sale deed on the ground that the execution of the sale deed attract payment. I state that I was requesting the defendant to repeatedly to execute the sale deed. The defendant was postponing the execution of the sale deed attracts payment of capital gains, and the defendant has executed some sale deed in favor of others, he will have to pay huge capital gains and classifiedly saying that as I'm already constructed a house on the scheduled premises and living in the house, he will execute the sale deed after sorting out his tax problem. Being his cousin, I agreed for the same and defendant requested me to pay till he makes all the arrangements. And according to his assertion, your lordship, he says that everything has been paid by 1981 itself. The whole sale transaction was concluded in the year 1981, but from 1981 to 1995, no letter has been issued on behalf of the plaintiff to the respondent, to the defendant, calling upon him to pay for the sale. Execution of the sale.
Yes.
Page 71. Page 71. Paragraph 3. Wherein he states that nothing has been issued by the defendant with respect to capital gains or income tax. It is true to suggest that the defendant has not given anything in writing stating that he has income tax problems, therefore he is only the performance of the agreement. This clearly shows that whatever statement that has been made by the plaintiff is a self-serving statement. Apart from that, your lordship, GPA was executed and respect to the GPA, which is exhibit P29. There's absolutely no averment or contention with respect to pleadings with respect to that in the plaint itself. There's no mention of GPA or the GPA order in the plaint. Subsequently, while filing the evidence affidavit, they state that the plaintiff states that there was a GPA and the sale deed was executed by the GPA order. Plaintiff makes no mention of either the GPA or the GPA order. And besides that, the GPA holder who executed the lease deed in favor of the plaintiffs was not examined at all. He in fact states that he is in favor of the plaintiff, but nothing has been decided with respect to that. And bring your lordship's attention to page number 70.
70?
72.
No.
In fact, in our written statement, the defendants are contended that the documents were executed under new influence. And also, we have stated that the terms provided therein are unconscionable and the terms are unfair.
72. 72 is further cross.
Further process.
Ah,
This statement we have stated that is undue, there is fraud and undue interest. Prove that there is a deposition at page number 72.
Hmm.
One Reddy two, a partnership for functioning during 1970s in Bangalore is proved. Yes, my wife defended CH-3 are the partners of the aforesaid company with many others. I don't know whether Reddy has taken loan from the Bank of Mysore. Yes, I was guaranteed the said loan with State Bank of Mysore of CH-3. Witness further says, I do not know on what capacity CH-3 took me as a guarantor. So this shows that there was some element of undue influence because he was acting as a guarantor for CH-3. CH-3 is the GP holder who executed this deed in favor of the guarantor here. Besides, they were also partners in a business. And whatever amount that has been paid from 1976 to 1981 were with respect to the partnership period. The amounts that were paid to CH-3 was with respect to the partnership.
yes.
And next question here, you gave the guarantee in writing. I signed some guarantee form. I do not know for whose debt I was guaranteed. Yes, I have put my signature on the printed blank forms. I do not know whether the forms were issued by the said retail company. And subsequent after that, whether you had transaction either by cash or by check with CH-3. I had one transaction with CH-3 paying 25,000 rupees when registered the lease deed of the scheduled property. And after that, you had any other transaction either by way of cash or check. I do not remember about other transaction. So all the whatever amount that was paid to CH-3 was paid with respect to the partnership deed, and it was entire amount was paid to the GP order. Nothing was the consideration at any given point of time was not passed to the original vendor, that is KD CH-3.
Yes.
Taken specific condition that the terms in the contract are one-sided and are also unconscionable in your lordships. Your lordships attention to exhibit B1. B1. Page number 149I.
Of
Page number 149I. Book is page number 1. I. The lessee shall on expiration or sooner determination of the term hereby granted deliver of the structure of the demised premises to the lessor, provided the lessor pays to the lessee for the structure erected by the lessee on the scheduled land at the prevailing market rate and in any event not less than a sum of rupees 2 lakhs. Here, A, while exercising his right on the expiration, in the event, let's say he gives the property back to the plaintiff, he expects them to reimburse the amount at prevailing rates. While on the other hand, he states that the lease, the option to purchase the property would be exercised at any given point in 98 years for a sum of rupees 1 lakh. That goes on to show that the terms are one-sided and unconscionable. And also, the trial court judge has also observed that there is no definitive term with respect to termination of the contract as well. Several terms that have been included in the exhibit B1 are one-sided and they mostly favor PD's term. Relied upon several allegations to plaintiff also admitted that it is admitted that the property concerning is a ancestral property. my submission is that since it's an ancestral property, the sons of CH-3, that is Vinod and Rajkumar have a right in the property.
Subsequently born sons.
Subsequent, your also, she says that the option was exercised in 1976.
By the time are they born?
At that point of time, they were born in 1980 to 1983. And that case has been set up only with the intention to show that the defendants do not, the children do not have any right over property. Had he submitted or had he made a comment in the page saying that he exercised the option to purchase in 1995, then both parties, that is the children, would have had the right. To evade that, he has made a statement that it was the exercise of option.
Your contention is that there is nothing in writing till 1980, till your birth, that he exercised the option. He'll consider.
He stopped making payment in the year 1981, and it's still in the same year as well, that is 1981.
He gets married. He'll continue.
ಇನ್ ಬಾಕಿದೆಲ್ಲ ಅರ್ಜೆಂಟ್ 41 ಎಲ್ಲ ಇದೆ ಸರ್ ಫೈನಲಿ. ಒಂದು ಆಗೋದ್ರೆ ಮೋಸ್ಟ್ಲಿ ಆಗುತ್ತೆ ಏನೋ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಏನಾರು ಇದೆಯಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 40.
ಇದೆ ಸರ್.
ಸರಿ. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
submission, my lords. Two fresh memos, my lords, with regard to education counseling, my lords, for tomorrow, your lordship.
What counseling?
MD, my lords, a stray vacancy, my lords, of permitting for the stray vacancy. Your lordship.
Yes, you filed it.
Filed it, my lords, with FR number.
Please see that.
Please, my lords, we will complain. Please.
Yes, serve the
Same
copies
thing.
also. Those are, that's important.
Please.
Yes.
37, P. Chinnappa.
Also, dependent of taking a specific condition that they are and also maybe not paid for. Such a case, where such HR is again necessary party to see the execution of the lease. Making we need to give an party to execute payment to credit. So, here was page number 83. The date of filing the suit and transcribing, 2004, their CH-3 was very much high. Not known as to why it was not examined.
83, 83 of the RFA paper book. Yes.
Here CH-3 alive, yes. When he was alive, he was not brought before the court. Apart from that, this sought by the plaintiffs is visionary debate. Even if they want to prove that the incident CPA are documents, court will have to take the entire action setup of protection. And as a gossip, you can see page number 63, page number 63 of the Regularization. It admits that he owned about 10 acres of land in high ground clearance, which is a problem for over 1,000 crores. Page number 63, land allotted to my father in high ground might be about 10 acres. It is suggested to me that 20 acres of land was allotted to my father. I stated that. Apart from that, page number 66 as well. At the bottom, page number 66 at the bottom. From the bottom, this group to suggest that I found the layout there and sold the sites. If it is suggested to me that I purchased the house site to Jayamahal Expensive in the year 1972, I state that myself and my wife purchased that. They have ample amount of properties in Bangalore. And he even admits that he has a bungalow in Kumar. That's being the case, there is no necessity for him to get another house in the associated property. So that there was some amount of undue influence and undue influence on the defendants. Everyone has been both at page number 168, 167, 168. 167.
Yes.
sometimes I stay at his house, where I used to consult him for any medical problem with myself regarding my children, more particularly my younger son. I consulted doctor regarding persistent cough and cold. At that point of time, my younger son was about 2 years old. Consultation was free, except for the laboratory charges. I had gone for I had earned a very good name in the community, my knowledge. Everybody of my community treats him with regard and respect. I have personal regard with also, but it was
Yes, this is, whose deposition is this?
Video of the limit of influence on both the defendant and also on the other.
Cross-examination by the plaintiff's counsel in OSO. Yes. Defendant being cross-examined.
So page number 148.
Please don't go up and down. Finish one deposition first. That is how you go about it, is it not? You're taking us to the plaintiff's cross-examination, then the defendant's cross-examination, then back to the plaintiff. Please go a little more systematically so that we are getting a little confused here. 148 is defendant's cross. Okay, fine.
Safety demanded by the plaintiff, and I have not received any consideration for the plaintiff as a
It's not cross. This is chief. This is chief. Just please verify, is it chief or cross?
Chief exam.
Chief. Which is why we said don't go up and down. Once one witness is over, you come to the next witness. First the chief examination, if you have anything to say there, and then the cross-examination. That is how you go about it. Yes. Yes.
I will execute say it has demanded by the plaintiff, and I have not received any consideration from the plaintiff as a witness. I submit that I have not issued any stamp with the for sum of rupees 1 lakh to the plaintiff. But then receipt is a false document and submit that I have not issued any stamp receipt for any rentals for the period November 1973 to December 1991. That is in the plaintiff.
Yes.
There is a specific question in the middle of page number 158. Specific question in respect to exhibit P16 as well. He clearly stated I have not signed exhibit P16 and P17 my signatures are full. Admittedly, I have not signed exhibit P18 as well. In this case, the contents of exhibit P16 where is there, where it has been provided that certain cash payments were made to the plaintiff or to the defendant. Mere admission will not have any, mere admission of the document may not have any evidentiary value or not. Each content, the entire content has to be proved by producing an independent document. For cash, where they have stated that cash has been made, that cash payments have been made. The plaintiff also has submitted a separate document to show that in fact a cash payment was made to lady station.
You don't want to take us to any portion of the judgment under appeal? What is in your favor in the judgment under appeal?
In respect to partition and a separate possession has been denied. On the ground that I should have issued a termination notice under the provisions of Transfer of Property Act, section 106. But after pronouncing the judgment, 279 crores.
279.
279.
Hmm.
279.
Hmm.
Below the order.
Hmm.
The suit of the plaintiffs in West so is different party.
Hmm.
And therefore it will dictate that the lease be dated so and so date executed and here she shall be as a power of attorney holder. On the deceased, depending on the brief marked as exhibit P1 is null and void and cannot be enforced against the plaintiff.
Hmm.
However, the claim of the plaintiffs in the suit OS 5 so and so for partition and separate possession and also delivery of possession including the mean profit rendering of the accounts are hereby dismissed. And this has been done for the reason that no termination notice was issued. But once the document exhibit P1 has been held as null and void, the question of tenancy would not arise at all and even issuance of notice. That it has been held as null and void.
There is no case that possession is not passed. There is no case that possession of the property has not passed. Hmm.
Yeah, maybe the asserting the right as buyers or purchasers of the property not as tenants.
Hmm.
Case also issuance of notice.
Hmm.
Company partition.
Yes.
Either in 1942, this is with respect to unconscionable contracts. Here, in 1943, there was a agreement between the parties that for a certain amount, a certain good would be given. But in 1951, the same could not be given owing to the increase in prices of goods. Paragraph number 9. The rate scope is either in 1943 and 1951, and the arrangement of 1943 was remain valid for more than half a century. A series of change took place in the years to follow, and apart from the fact that ownership of the railway changed, and ultimately became part of the Western Railway, unprecedented changes swept through the entire country. In this process, and in the years to follow, there has been escalation of costs in every field of activity, and it would indeed be unconscionable to direct the railways to continue the rates fixed in 1943 for a period which would expire only 6 years hence. In the facts and circumstances of this case, we are inclined to agree with the counsel for appellants that the learned trial judge had taken a very pragmatic view of the situation. On facts, we are inclined to agree with the position that the plaintiff respondent was not entitled to sue for recovery of money. In judgment.
This was haulage charges. This was haulage charges. Charges. Yes.
On that,
Hmm.
what I am saying is that since an amount of conduct has been fixed for 98 years, such a clause in any contract would be unconscionable and unfair.
Yes.
Page number 14. Paragraph number 6.8.
Yes.
Term of a contract will not be final and binding if it is shown that the flat purchasers had no option but to sign on the dotted line on a contract paid by the bidder. The contractual terms of the agreement dated so and so are expressly one-sided, unfair and unreasonable. The incorporation of such one-sided clauses in an agreement constitutes an unfair trade practice as per section so and so of the Consumer Protection Act. Since it adopts unfair methods or practices for the purpose of selling the flats by the bidder. In view of the discussion, we have no hesitation in holding that the terms of the apartment buyers agreement dated 8/5/2012 were only one-sided and unfair to the respondent flat purchaser. The appellant bidder could not seek to bind the respondent with such one-sided contractual terms. This is the Indian law based on principles of equity. This is the Indian law based on justice, equity and good conscience. We reiterate that provision. Though long term by itself as a period of redemption is not necessarily a clause on equity, but in changing circumstances of inflation and phenomenal increase in the prices of real estate. In this age of population explosion and consciousness and need for habitat, long term, very long term, taken with other relevant factors would create a presumption that it is a clause on equity of redemption. Continuing from the paragraph number 32, your lordships. It is a settled law in England and in India that a mortgage cannot be made altogether irredeemable or redemption made reducible. The law must respond and be responsive to the felt and discernible compulsions of circumstances that would be equitable, fair, and just, unless there is anything to the contrary in the statute. Court must take cognizance of that fact and act accordingly. In the context of fast changing circumstances and economic stability, long term for redemption makes a mortgage an illusory mortgage, though not decisive. It should prima facie be an indication as to how clause on equity of redemption should be judged. Paragraph is page number 59. This is with respect to readiness and willingness.
Yes.
Paragraph 14. There is a distinction between the terms readiness and willingness. Readiness is the capacity of the plaintiff to perform the contract, which includes his financial position to pay the sale consideration. Willingness is the conduct of the party. In the instant case, even according to the concurrent findings recorded by the court, it would emerge that the plaintiff had been able to successfully prove the sale agreement dated so and so, on which date rupees 2005 was paid by the plaintiff to the defendant. The evidence on record tendered by the plaintiff came to be accepted by all the courts and judgments from courts of appeal. It also indicate that further amounts towards sale consideration in a sum so and so was paid by the plaintiff to the defendant on so and so, and sale was endorsed by him. As per the recital in the agreements, the defendant was required to get the suit land surveyed, and as such, the total consideration was agreed to be settled after such survey. On the one hand, the plaintiff contends that the defendant never got surveyed the suit land. On the other hand, pleadings and evidence of the plaintiff is silent on steps taken by the plaintiff as expected of a reasonable person, which has not been taken in the instant case. Namely, plaintiff has not produced any evidence, either oral or documentary, to establish that there was any demand made by him for the land being surveyed by the defendant. No witnesses have been examined on behalf of the plaintiff to establish that at any point of time, there has been demand made by the plaintiff with the defendant by calling upon him to get the suit land surveyed as agreed under the agreement of sale. It is for the first time after a period of 3 years from the date of agreement. Namely, on 30th of May 1996, legal notice was issued. Or in other words, the plaintiff was silent for a period of 3 years in enforcing of the agreement of sale. It is for this specific reason that the airport, by rejecting the prayer for specific performance, has recorded a categorical finding to the following level. Even in this case, your Lordship, the court holds that there is a delay of 3 years starting from the date of execution of the sale agreement. If we were to treat the lease deed as a sale agreement in the instant case, the appellant ought to have issued a notice calling upon the defendant to execute the same deed within 3 years, that is starting from 1975. After 1981 until 1995, it doesn't take any step with regard to execution of the same deed. Not a single letter has also been issued in respect of that. Only in 1995, 1996, he calls upon the plaintiff defendant to execute the same deed in his favor. Paragraph number 80, Your Lordship. The continuous readiness and willingness is a condition precedent to grant the relief of present performance. The trial court has rightly held that the plaintiff has not sufficiently explained and proved that he was always ready and willing to perform the part of the contract. In this case, even if we were to assume that readiness was proved by way of paying the payment, willingness has not been proved. The conduct which also includes buying of stamp papers. Admittedly, stamp papers were purchased in the year 1996. He could have purchased it as stamp paper back in 1982, 1998, right after paying the entire sale consideration. It's a lapse of 15 years, and that itself shows that he abandoned his life. Paragraph number 20, the long unexplained delay and silence on part of the plaintiff in this regard while in the witness box is not entitled to plaintiff to degree of specific performance, and it is for this precise reason the trial court has noticed has refused to grant the equitable relief which has been reversed by the appellate court without assigning proper and cogent reason, and the one assigned are a tangent or in other words contrary to the facts. Paragraph page 71, paragraph 18.
Yes.
There are facts on record to justify the interference of undue influence. The omission to make an allegation of undue influence specifically not paid to the plaintiff, being entitled to relief on that ground. All that the court has to see is that there is no surprise to the defendant. To tell that mere lack of details in the pleadings cannot be a ground to reject the case for the reason that it can be supplemented to by the parties. In my case, I have specifically pleaded in written statement that the element of undue influence on both the women and cash side. Page number 83. Paragraph 14. A detailed consideration of the evidence on record. The courts below have come to the conclusion that the clauses in the agreement have neither been amended nor varied. Clearly, because the defendants were pursuing the application filed for permission before the LNDO, it cannot be said that the date fixed for performance of the agreements could be extended. We agree with the findings of the courts below that the suit ought to have been filed within 3 years from the 31st of March 1975, which was the date that was fixed by the agreement. The submission made on behalf of the plaintiff that Part 2 of the Article 54 of the Schedule of the Litigation Act applies to this case, and that the suit was filed within limitation, as the refusal of the defendants was only in the year 1987 is not acceptable. Moreover, the plaintiffs have not performed their part of the agreement within a reasonable period. As per the agreement, the plaintiffs were given the right to get the sale deed executed in court in case of failure on part of the defendants to execute the sale deed by 31st March 1975. The plaintiffs filed the suit 12 years after the date fixed for performance. It is relevant to refer to the judgment of this court in case Vidyanathan versus Survivor, and then straight to paragraph 15. The silence maintained by the plaintiffs for about 12 years amounted to abandonment of agreement, and we approve the finding in this regard. We have get it. Judgment squarely applies to my case. Because it's stated it has been done between 1981 to 1990. There will be a relevant paragraph with a page 86 here. Paragraph 80, page number 86. Section 90 of the Indian Evidence Act, will provide that in terms thereof, the authenticity of the recitals contained in any document is presumed to be correct. The High Court therefore committed a manifest error of law in the provisions of Section 90 of the Indian Evidence Act, and thus fell into an error in formulating the substantial question of law. As the purported substantial question of law was formulated on the wrong reading of Section 90 of the Indian Evidence Act, the impugned judgment cannot be sustained. We may furthermore notice that even if a formal execution of the document is proved, the same by itself cannot lead to a presumption that the recitals contained therein are also correct. The mere execution of a document, in other words, does not lead to the conclusion that the recitals made therein are correct to the statutory provisions contained in Section 91 and 92 of the Evidence Act. It is open to the parties to raise a plea contra it. That page is on 13. 99.
Yes.
The stage of evidence when any document paper is formally produced for being treated as a piece of evidence, the court looks at two basic aspects. Firstly, the existence of the document on the court's record, and secondly, the proof of its execution or its contents being sufficiently deposed to by a witness having requisite knowledge thereof. Whereafter, the document in question is marked as exhibit. At the stage of exhibiting any document as a piece of evidence, the truth of what is stated in the document is not considered. It is left open to final evaluation at the trial after cross-examination, and the entire testimony of the witness about the existence and contents of the document is weighed in conjunction with various other factors emerging during the trial. At the final evaluation stage, the trial court concludes whether the document speaks the truth and decides what weight to give it for final decision. In other words, its evidentiary value is analyzed by the court at the time of final judgment. Paragraph 100. This court in Narmada Devi Gupta, so the legal position is not in dispute that mere production and marking of a document is as exhibited by the court cannot be held to be due proof of its contents. Its execution has to be proved by admissible evidence, that is, by the evidence of those persons who can vouchsafe for the truth of the facts in issue.
Yes.
The basic fact of the matter is not in dispute. The agreement was entered into on or about 1/10/1978, apart from the vague statements made in paragraph 6 of the plaint, as noticed hearing before. The plaintiff has not placed any material on record to show that at any point of time, and far less within a period of 3 years from the date of the said agreement, he never asked defendant one to execute a deed of sale in his favor, or tendered the balance amount of consideration to her. The plaintiff admittedly served the notice dated so and so upon defendant to alone, that is much after the expiry of the said period of 3 years. He only upon having come to learn that defendant one had transferred the property in suit in favor of the appellant hearing filed the suit. Admittedly, defendant number 1 did not receive any notice. Due to paragraph 14, in terms of aforementioned provision, it is incumbent upon the plaintiff both to aver and prove that he had all along been ready and willing to perform the essential terms of the contract which were required to be performed by him. Paragraph 15, form 47 and 48 of appendix also describes the manner in which amendments are required to be made by the plaintiff. Indisputably, the plaintiff has not made any amendment to that effect. He, as noticed here before, merely contended that he called upon defendant 2 to bring defendant 1 to execute the registered statement. Apart from the fact that the date of the purported demand has not been disclosed, admittedly no such demand was made upon defendant 1. We may notice at this juncture that the plaintiff in this evidence admitted that defendant one had revoked the power of attorney granted in favor of defendant number two. In his deposition, he merely stated that such revocation took place after the agreement for sale was executed. If he was aware of the fact that the power of attorney executed in favor of defendant two was removed, the question of any demand made upon and made demand by him upon defendant to bring defendant one for execution of the agreement for sale would not arise at all. Furthermore, indisputably, the said power of attorney was not a registered one. Defendant number two, therefore, could not execute a registered deed of sale in his favor. The demand, if any, for execution of the deed of sale in terms of the agreement of sale would have been thus made only upon defendant one. The owner of the property, the balance consideration of rupees 10,000 also would have been tendered only to defendant one. As indicated here in the report, the purported notice was issued only on 8/8/1984, that is much after the expiry of the period of 3 years within which the agreement of sale was required to be acted upon. Page number 157. Of this court, therefore, there is no matter of doubt that a plaintiff in a suit for specific performance of contract not only must raise the plea that he had all along been and even on the date of filing of the suit was again unique to perform a contract, but also prove the same. Only in certain exceptional situations where, although in letter and spirit, the exact words had not been used, but readiness and willingness can be cut off from reading all the arguments made by the plaintiff as a whole, coupled with the materials for the records and file of the suit to the said effect, and statutory requirement of section 16C of the specific contract may be compared with paragraph 30 of the. There is another aspect of the matter which cannot be lost sight of. The plaintiff filed the suit almost 6 years from the date of entering into agreement to sell. He did not give any material on record to show that he had ever asked defendant one, the owner of the property, to execute a deed of sale. He filed the suit only after he came to know that the suit land had already been sold by her in favor of the appellant hearing. Furthermore, it is obligatory on part of the plaintiff for obtaining a discretionary relief having regard to section 20 of the Act to approach the court within a reasonable time. Having regard to his conduct, the plaintiff was not entitled to a discretionary relief. Statement is 167. Yes, another statement has been cited in several other documents. Paragraph number 10 has been consistently held by the courts in India for certain early English decisions that in the case of agreement of sale relating to immovable property, time is not of the essence of the contract unless specifically provided to that effect. The period of limitation prescribed by the Limitation Act for filing a suit is 3 years. From these two circumstances, it does not follow that any and every suit for specific performance of the agreement, which does not provide specifically the time is of the essence of the contract, should be agreed, provided it is filed within the period of limitation, notwithstanding the time limits stipulated in the agreement for doing one or the other thing by one or the other party. That would amount to saying that the time limits prescribed by the parties in the agreement have no significance or value and that they mean nothing. It would be reasonable to say that because time is not made the essence of the contract, the time limits specified in the agreement have no relevance and can be ignored with impunity. It will also mean denying the discretion vested in the code by both sections 10 and 20 as held by Constitutional Bench of Proceedings. In other words, the court should look at all the relevant circumstances, including the time limit specified in the agreement, and determine whether its discretion to grant specific performance should be exercised. Now, in the case of urban properties in India, it is well known that their prices have been going sharply over the last few decades, particularly after 1970. He makes a note of, they even give an explanation as to why after 1970 there was a lot of inflation that in this case, the suit property is a house property situated in Madurai, which is one of the major cities in the cities of Tamil Nadu. The suit agreement was in December 1978 and the 6 month period specified there for completing the sale expired with consequence of date. The suit notice was issued by the plaintiff on 11/7/1981, that is more than 2 years after the expiry of 6 months period. The question is, what was the plaintiff doing in this interval for more than 2 years? The plaintiff says that he has been calling upon defendant number 1, 2, 3 to get the tenant vacated and execute the sale deed, and that the defendants were postponing the same, representing that the tenant is not vacating the building. The defendants have denied the story. According to them, the plaintiff never moved in the matter and never called upon them to execute the sale deed. The trial court has accepted the defendant's story, whereas the High Court has accepted the plaintiff's story. Let us first consider which story is most probable and acceptable. For this purpose, we may first pronounce the terms of the agreement. In the agreement of sale, there is no reference to the existence of any tenant in the building. What it says is that within the period of 6 months, the plaintiff should purchase the stamp papers and pay the balance consideration thereupon. The defendants will execute the sale deed, and that prior to the registration of the sale deed, the defendant shall vacate and deliver possession of the house to the plaintiff. There is not a single letter or notice from the plaintiff to the defendants calling upon them to get the tenant vacated and get the sale deed executed until he issued the suit notice on 11/7/1981. It is not the plaintiff's case that within 6 months he purchased the stamp papers and offered to pay the balance consideration. To paragraph number 13 of the same document, page number 170.
Yes.
In case before us, it is not mere delay. It is a case of total inaction on part of the plaintiffs for 2.5 years in clear violation of the terms of the agreement which required him to pay the balance, purchase the stamp papers, and then ask for execution of sale deed within 6 months. Further, the delay is coupled with substantial rise in prices. According to the defendant, 3 times between the date of agreement and date of suit notice. The delay has brought about a situation where it would be inequitable to keep the ready for specific performance of the tenant. Even in our case, it was mandated that a notice has to be issued when an option to purchase was exercised by the patient, but that has no notice has been issued. No letter expressing his consent has been issued also. And apart from that, stamp papers were only purchased in the year 1999.
You also never called upon him to vacate. Or you also never called upon him to vacate and.
We never. It's from 1999. Paragraph 21, page 199. The interlineations have been made at both places in the same deed. The word avadi had been mentioned at 3 places in the margin of the same deed. The appellant did not attend the said word by putting this signature at the time of registration. Attestation justifies sufficient genuineness of the document. Attestation and execution are different acts, one following the other. Execution includes delivery and signing of the document in presence of the witnesses, and also the whole series of acts or formalities which are necessary to render the document valid. Attestation of sale deed is imperative. In the instant case, we find that animus to attestation remain totally absent. It is settled legal proposition that the document may be admissible, but probative value of this entries contained therein may still be required to be examined in the facts and circumstances of the particular case. The case is required to be examined from another angle also. The appellant had purchased the land for a consideration of ₹10,000. On 23/4/1986, he sold the land on the very next day for a sum of 10,000, reserving his right to purchase the land for the same consideration within a period of 10 years. In normal circumstances, the vendor would not agree for reconveyance for the same consideration for the reason that the value of the land generally goes upward and within a period of 10 years, it could have at least become double. The aforesaid circumstances make it abundantly clear that the appellant has made interlineations after the documents could be executed The said additions were made without the consent and knowledge of the respondent. Even at exhibit P29, your lordships, interlineations have been made at page number 1 and 2. And admittedly, defendant's signature is nowhere to be found on page number 1 and 2. So the document has been admitted at the time of marking.
For that argument, it would be important as to what the interlineation was. It is not, you're not saying that the entire, the terms which were against you are interlineations. It is not your case. Your case is that 1 and 2 does not have the signature. It is 3 which has the signature. And in 3, the sub-registrar says there is one interlineation in page 1. And that interlineation is there. That is not the interlineation that works against you. It is the other.
So replace the page. For that means. Had it been a genuine interlineation, my signature would have been found in the G. At the time of making it.
So you're not denying the GP as such. You're saying that page 1 and 2 are something else.
That says that the document is treated as an exhibit or any document has been executed, which also encompasses dates of other documents. Stamp duties have to be paid for both lease and sale. In this case, under the lease deed, stamp duty has been paid only with respect to the lease. Nothing has been said, nothing has been paid towards the sale.
Yes.
I'll briefly try to meet, my lord, the points which my learned friend has so effectively made. Not the submission, my lord, was on facts essentially. So far as the law is concerned, my lord, I don't think there is much of controversy between us. Both of us, my lord, submit that agreement has to be properly drawn up. The terms of the agreement have to be complied with. And there is an element of discretion to what extent that is there. What are the conduct of the parties and whether promptly the person has come to court. These are the usual parameters, my lord, so far as enforcement is concerned. The other parameters, my lord, relates to undue influence and the conduct of the parties. And it depends on the plea that they take and at what point of time that influence, my lord, was so-called influence was exerted. That's why, my lord, I took some time in the opening remarks to, my lord, place for your lordship's consideration the genealogical tree, the relationships of the parties, and the cordiality that remained, my lord, throughout. Now, to countenance an argument that agreement itself was shrouded in suspicious circumstances, or it was an outcome of some undue influence, my lord, my submission is there is no material to reach that conclusion. Now also my learned friend said my client was a doctor and he used to consult him. His children were also treated by him. Children, my lord, came much later. But the time the agreement was signed, the fact remained that they were very cordial. It was a close-knit family. They were practically living in the same house, same premises. He was not married at the time. And he thought, it's time that I encash whatever assets I have. That is how this agreement was signed. And it is, I must say, my lord, a somewhat unusual agreement. It's not the normal agreement that we usually come across. And that is, my lord, reason is because of the relationship of the parties. And, my lord, we can't lose track of the time that agreement was entered into. And also the fact that it placed a requirement on the purchaser to build a house and spend 2 lakhs rupees. Land was 1 lakh. Price was, the building was 2 lakhs. Normally, it's the other way about. You pay a bigger sum for the land and you spend lesser for the building. These are, my lord, conditions which were agreed. And there is really no way in which they can overcome that. Some controversy, my lord, is sought to be raised about the payment of consideration. The submission is that the amounts indicated in cash, to whom it was paid, we didn't say that it was paid to your judgment, that is to the JPA holder. We said it was paid to him. Not so far as we are concerned, this J.R. CH-3 is a family member. He has a power of attorney. And your lordships have seen the deposition in the other case also, my lord, where this is specifically referred to. At no point of time did the other side even suggest that J.R. CH-3 was not doing something fairly, that he was appropriating something which was not due to him. No such allegation, at no point of time it has come. Even the very fact that the power of attorney was executed, which enabled him to receive the money, give the receipts, that's also not in dispute. But a very bald kind of plea is made to say that I have not received the consideration. Now, my lord, this, if I say that I have paid money to the plaintiff, that is to the defendant in my suit, and that money is actually received by the agent, and the agent is the one who signs the agreement also. He is the one who receives the money. He is the one who gives me a receipt also, which later is confirmed by the principal also. So in a situation like that, my lord, the fact that I just stated that I have given the money to the defendant makes no difference, because the tender is to the defendant through his agent. Then, my lord, the other submission was, why did I not file the suit early? Why did I wait? My lord, this fact will assume some importance. In most cases, my lord, an initial advance of some 10% or 20% is given at the time of agreement. It will only be an agreement for sale. It will stipulate the full consideration. It will also stipulate when the sale deed is to be executed, usually a time limit, 6 months, 8 months, 1 year, whatever. Sometimes, my lord, something intervenes in between, and that intervention is, supposing it's agricultural land, the buyer wants it to become non-agricultural. In Karnataka, we had a restriction. A person having non-agricultural income cannot buy agricultural land at all. Complete ban. So, like that, so the vendor may have to go and get an application to the Revenue Authority under Section 95 of the Land Revenue Act, get it converted. Or there is some other problem related to green belt. Or if the land is within urban area, it may be classified as a public, semi-public, which he wants for commercial. The change of land use has to be like this number of factors. Or there may be some suit filed by some member of the family to say I have a right in it. Some order is made. Even if no order is made, the current condition will be that you please go and resolve that suit. So these type of conditions, my lord, are usually there. Now, in such a situation, the performance of the sale deed or the execution of the sale deed will get linked to that duty to be done by them. Now, in this case, there is no such issue at all. And in most cases, my lord, a small amount is paid. Then after these problems are, these impediments are cleared, a larger sum is made. At that time, usually it is insisted that the documents of title must be handed over to the purchaser. Possession is not given. And then when the sale deed is to be executed, possession will be given and full payment. This is a normal routine. But in a case like this, my lord, here is a peculiar case where the entire consideration was paid. There is an issue, they tried to raise an issue that is not paid, my lord. I respectfully submitted that there is enough evidence to prove that payment has been made. Now, in a situation like this, my lord, if I have to ask myself a question, what is the prejudice that is caused to the other side by my not asking for a sale deed in maybe in 1980 or 85? The answer to that question would be obviously nil. The explanation I have given, my lord, in the plaint is, I don't know for what reason he didn't do it. Now, my lord, there's one section in the Income Tax Act, my lord, which may throw some light. It's in the old act, which has now been repealed in 2001. Section is 230 capital A. Income Tax Act. I no need to read it, I'll just mention it is a well-known provision. Most people who have dealt with real estate will know it, my lord. This was a provision which was introduced, my lord, in 1964, few years after the act came into force. They wanted to have some control over anybody who sells property, because many times property sale takes place, cash transaction in the olden times, my lord, payment of consideration was paid fully in cash, officially only. And they would say this entire cash payment is made, because many people didn't have bank accounts also, especially in the rural side. They were taking cash only. So that was how it was done. So this entire transaction would go outside the purview of the income tax regime. So they introduced a provision. Initially, it said that 12,000 rupees. Anybody who sells a property more than 12,000 has to go to his income tax officer, give a form and get a certificate from him. Without that certificate, the property can't be registered with the sub-registrar. That 12,000 became 50,000, it became 2 lakhs. And thereafter, my lord, it was deleted in 2001 when a new chapter was introduced in the Income Tax Act, Chapter 20C, which provided for a form to be given and a Form 37I to be obtained. It's the preemptive purchase provision. So one of the issues that there is evidence on that issue, when we asked him about it, he said, I have income tax issues, I cannot go forward, so you please wait. That is our explanation. Though my learned friend criticizes it to say that you didn't give this explanation in your plaint. But the fact remains that there is a problem, that this certificate is not obtained. This is a requirement of law. It is not their case that I was ready and willing to get this certificate. My case is that there were problems according to him, and I can't, my lord, do anything more than make a request to him to say, let's go forward with the transaction. Then, my lord, another aspect is, at what point of time do they, for the first time, my lord, raise this issue? Because in 1995, when the correspondence takes place, a date is fixed, a draft of the sale deed is given, the draft is initialed by him, and the draft comes back to us, and a date is fixed in November, and he doesn't come. It is at that stage, my lord, that we issue a notice, and that notice, my lord, is exhibit P24. P24. It's at page 91 in the RFA papers, not the second volume.
Yes.
Letter is at 80. Letter, my lord, is at 91. Your lordships may have to take the volume, my lord, which has the exhibits. That is plain 5955, that volume.
It is of RFA paper.
RFA paper book. There are 2 paper books, my lord, 508 and 509. Please take the 509 paper book.
This is the cross objection paper.
Page 91, exhibit.
Paper book in 509, RFA 509.
509, there is a paper book.
509, Ali. Lord, what has happened is because there are 2 suits, we have separated, Lord, the plain written statement and documents.
Additional paper.
Yes, I don't know, my lord, how it is numbered in the court. It's the plaint of Mr. Vinod Kumar. 5955. First page is that. In that, my lord, page 91. 11/11/95.
Yeah.
We are expecting you to come over on the 9th as promised by you for execution and registration of sale deed in favor of Arvind and myself with respect to property number so and so. In the meanwhile, on 31st October, I have already taken challan from Deputy Committee Director, Government Treasury for remittance of stamp duty into Reserve Bank for getting sale deed, which was approved by you, duly embossed. Since you did not come on 9th, I have not remitted the amount in the Reserve Bank, though the sale deed is ready. Kindly advise me the date you propose to come over for execution and registration of sale deed, because I am holding the cash I had drawn for remittance towards stamp duty. I trust this finds you and family in good health and cheers. Look forward to receiving. Then nothing happens. Then there's another letter at page 25, that is few days earlier. Then we have to issue a notice about 4 months later. That is at page 96. All this is recapped in that. You are supposed to come, you didn't come, etc., etc. Now, the reply to this assumes some importance at page 101. First para at 102. He doesn't deny the agreement, undue influence, nothing. Our claim states that it is true, page 102, fourth line, that registered lease agreement was entered into between power attorney holder and our clients and your clients. According to the said agreement, your clients have to pay a monthly rent of 100. Our client states that your clients have not paid amount by way of rent from the date of the said lease. The same was demanded by our client number of occasions. Good relationship between client. Our client made oral request for the sum. Rent was never paid. Hence, on that ground, your clients have to vacate. So it is not their case that this was some undue influence, fraud, this, that. They say, you're supposed to give me rent, you're not giving me. I kept on asking you. Our relationships are very cordial. And this is being said, my lord, in 1996. So this entire case they're trying to now build, that there was some hanky-panky. And one more thing, my lord, is that in this notice, they don't reply, they don't say anything or grievance against J.R. Seshadri. My lord, if he had given a power of attorney and the power attorney had received money, he's given me a receipt, I had transferred money to the account from my account, all that has happened, the immediate response should be, what agreement you're talking about? I don't know about any agreement. You have might have taken some signatures on me. And what? I have not received any money from you. And who is Seshadri? I have no idea about who he is. Because it all, the previous correspondence shows all this. Then will not please see the next para. Further, our client states that as per agreement, your clients have to pay 1 lakh to invoke the clause relating to sale of property. That means they are fully aware that such an agreement was entered into, that such a clause was there, that that payment was liable to be made. Then he goes to non-payment. According to agreement, your clients have paid only 50,000. Balance 50,000 not paid till date. Our client denies receipt of any other payment. Our client states that he never promised your clients that he was ready for the registration of sale deed on 8/11. Our client states his wife wrote a letter to so-and-so stating that the rent was not paid and balance 50,000 was not paid. It's only after receipt of said letter, your clients have approached you to issue the notice. Our clients further state that the said lease was entered into 6/2/75 between your clients and the power of attorney of our client. So nothing more, my lord. But your clients have approached you in 96 after a long lapse of 21 years for issue of legal notice. That shows that you have no right whatsoever. So nowhere do they say in this.
The principles. It is the principles.
Instruction or GP orders.
No, this is sent on instructions from the principal only. They have not denied this also. They don't say that I didn't issue instructions.
Sri Kumar D. Sheshadri, number 25, Trivandrum.
Our client, my lord, at page 101, bottom, fourth line, your notice dated so-and-so to our client, Sri Kumar Sheshadri, was handed over to us with instructions to reply. So on his instructions. Nor does he say in his evidence that this is also cooked up. I never instructed any lawyer. Maybe J.R. Seshadri instructed. And to make an allegation of collusion, fraud, misstatement, full particulars have to be given. Nothing is given. So this entire argument which they are now trying to build, my lord, to throw some light, dust on the agreement, my lord, is a clear afterthought. Then the next argument, my lord, was that these bank statements, their photocopies should not have been admitted. Lord, I have perused the originals, my lord. They are documents certified by the bank. It's not just I taking some photocopy and producing it. It bears the bank manager's signature with the seal. That's admitted in evidence, proved, and no cross-examination on that, that this is a forged document, this is not a document which is genuine. They are not P4 and P7. Both are duly signed by the bank manager. Then they're trying to now, my lord, bring in another aspect to say that some amount has come from my daughter's account. My daughter was supposed to be a partner with some Mr. Reddy in some transaction. There is a bank account which shows her name. So these transactions have something to do with that transaction. It has this payment, even if it has made nothing to do with this transaction, is what they're trying to, my lord, insinuate. For that, my lord, the answer is, after all, my lord, we can take note of the fact that in Indian families, the father, my lord, if he has a bank account, unless there is some animosity or some child has left the house and gone away, or there is some other issue relating to that, even married children, my lord, parents still maintain a bank account for them and look after their investments and help them to manage their finances till the father and mother can actually manage to do it. They grow very old, then they will leave it to the children. Even sons-in-law, my lord, to some extent are kept away from what parents give daughters. So if I have a daughter, I have given this money to her and it's in her account and she has some business transaction with somebody and there are receipts issued, payment is made regularly and the whole amount is paid, to now say that again for that no foundation. There could be a foundation to say, yes, I have received all these monies. My agent has also received them. Somebody, Gayatri, maybe your daughter, whoever it is, has given this money. This relates to some other transaction which you had. It has nothing to do with the sale transaction.
No such contention in the written statement also.
No suggestion. Nothing in the written statement. Nothing suggested to our witness also to say that your daughter had some other transaction. If she had given some money to CH-3, it is relating to something else. Then, my lord, there was an attempt made that this consideration and rent, there are all some mix-up. My submission is there's no mix-up, my lord. The document is very clear. It clearly indicates which is towards consideration and the monthly rent, dates, everything is there in the receipt, my lord. P17 makes the position abundantly clear. The other submission, my lord, was P19 is a certificate issued by the chartered accountant. Now, the submission, it appears to be made was, the chartered accountant says that he did not see P18 letter. But P18 is another letter written by me. If the chartered, to the other side, chartered accountant is not speaking about that letter. He is only saying that my advice was sought. There's a capital gain liability that is likely to arise. So he came and asked me, what is that capital gain liability? And I worked it out and I gave them the figures and he gives a certificate to say, I was consulted like this. This happening many years later. He is examined. He says, yes, they came, they asked me. And our case is, yes, the opposite side, defendant one, had these problems. So the postponement of the sale was because of those reasons. He had an income tax issue. He could not get 230A certificate on compliances. So then he also had this problem about how much capital gain I have to pay. So our client said, all right, Baba, whatever is the capital gain liability, I am willing to pay an extra that. Let me bear that. For that reason, they went to chartered accountant. The chartered accountant gave that advice.
Yes.
So the chartered accountant not being aware of any other letter, my lord, is of no significance at all. Then, my lord, on exhibit P20, the draft sale deed, I've already made my submissions, but there's an initial on that. And they have, of course, said that I'm not initialed every page.
He does not deny his signature on that initial.
No, he denies it. In cross-examination, he says that's not my initial.
Yes.
But the sequence, my lord, will make things clear.
Yes.
Then, my lord, P29, the GPA, my lord, much argument has been addressed, my lord. I don't want to again repeat it, my lord. I think the position is clear. It's the same type. If you can just see the naked eye will show, my lord, that it is not something else. It's the same sequence of stamp paper. It is signed before the registrar.
Yes.
And he has attested the correction also. And more than anything else, my lord, let me assume everything against me. Supposing that's a cooked up document. Now, my lord, the first thing that they would have done is to say, who is this J.R. Seshadri? I never gave him any power to enter into any agreement. I didn't give him any power to issue a receipt. I didn't give him power to receive money from you. And on what basis you did? Come on, show me the power of attorney on the basis of which you have acted. They could have done it when, not now, but in the 80s. That is not done. Then everybody acts on that document. He receives the money, and the deposition in the other suit, my lord, which the Honorable Court has seen, makes a position very clear. He categorically admits that GPA was given in favor of Seshadri relating to this suit property. So, my lord, they can't really wriggle out of that by these arguments. Then my learned friend just now made a submission on stamp duty. My lord, it's nobody's, my lord, if an instrument attracts a stamp duty under two heads, then you pay the higher of the duty. So the duty that was paid there was on the lease agreement and the consideration that was agreed to be paid as per the applicable Stamp Act. Now, nobody objected to it. It's exhibited, and till date, no one has raised an objection that this is an inadequately stamped document. Even in their appeal memo, they don't raise anything like this. The other submission, my lord, was that PW2 is a neighbor. He makes a statement that this is joint family property. My lord, what evidentiary value will that have? If my neighbor comes and says that my property is my joint family with my children, I think, my lord, that would have no evidentiary value. It is not his property. He is not my brother. He is nothing connected to the family. He just sees my children going and coming into the house every other day, and he says, this is joint family property. Then plaintiffs have to prove readiness and willingness. Now, I wholeheartedly agree with that. In this case, the plaintiff has proved and has actually done whatever it has to do. There was nothing left to be done.
Yes.
Then, my lord, on the preemption notice, Lord, your lordships may have to please permit me to just show two sentences in the agreement, my lord.
Yes.
P1, that is at page 39. The argument is that the document refers to a certain procedure to be followed, and that procedure is not followed for giving notice. My learned friend, my lord, relies on in the document begins, my lord, at page 39. At 49, clause number 6. All approvals.
All approvals.
All approvals, consent, and notices to be given under this present shall be in writing, and save as are herein otherwise provided for, shall be signed by or on behalf of the lessor, and any notice given to the lessees shall be considered as duly served if the same has been delivered or posted by registered post, addressed to the lessees at the premises hereby demised. Now, the argument is that this is not followed. But please see the preemption clause, my lord. That is at page 47, 2 pages earlier. Clause J. The lessees having been required to do so by lessor, lessees have deposited a sum of rupees 50,000 only to be held by lessor as a deposit, which deposit shall not carry interest. The said deposit shall be returned by the lessor to the lessee on determination of this lease. And in the event the lessee is exercising the option reserved to them hereinafter to buy the demised premises from the lessor, this sum shall be adjusted towards the agreed consideration of 1 lakh for the absolute sale of the scheduled property. This doesn't talk of any notice. Now, my lord, a preemption right, if it is given usually in Hindu undivided family properties on partition, lord, there is a preemption right given. That this property is allotted to A, if A has to sell it in future, he must give a notice in writing giving 6 months to the other owners so that if they want to buy, they can buy. Otherwise, he is free to sell. This is not such a provision at all. This is clearly a right given to me that I can exercise the right. So question of any notice may not arise at all. Then my lord, 6 is talking about notices to be given to be by the lessor to the lessee. If he has to give me a notice of termination, then he must write it, put it down in writing and send it to me in this registered address, not vice versa. Firstly, I don't have any obligation to issue him any notice. Secondly, there is no provision requiring that to be done.
He says I and J read together would mean that the contract itself is unconscionable, is the contention. He says that if you want to, if the lessees, if you want to, if the lessor wants to terminate the contract,
Yeah.
then he has to pay to the lessees for the structures erected by the lessees on
Yeah.
the scheduled land at the prevailing market rate, and in any event, not less than 2 lakhs.
Ex-
And on the converse, if you are purchasing it, it is 1 lakh at whatever time.
Correct.
That is
Correct. The
contention.
argument is that. Now, my lord, take the case of this KDB lease deeds, my lord. All these statutory authorities execute MUDA and others, my lord, for industrial development and all. It says the value of the land is X. They fix a rent. It's a 10-year rent period. Every year you have to pay this rent, you have to give the security deposit, and you have to comply with these conditions. Once you comply with all these conditions at the 10th year, after they are satisfied, then you have a right to get that property conveyed to you at the rate fixed. This is a very normal term in a contract. I don't understand how it can be unconscionable. It is a full agreed price is paid, plus a onerous covenant is put on the purchaser to say you must spend this much money and build. Thereafter, you are asked to pay this money, and then you have a right to convey the property to you. Now, supposing, my lord, let us say the purchaser paid only 90,000, didn't pay 10,000 more. Let's examine a situation like that. Then what are the options for the lessor? Lessor can say, sir, you are supposed to pay me 1 lakh. You not paid me. So now so much time has gone by. So either I call upon you to pay with interest, or I have a right to terminate. My lord, even if you don't have a termination clause in a contract, that right is inherent in law. So he can issue me a notice to say you're not complied. Therefore, I'm terminating this contract. And I'm not liable to convey this property to you. And I'm also not liable, you have to pay me damages, whatever it is, whatever relief they can get. So if you provide that I am going to invest, after all, not why am I investing? Because I want to live there. He actually lived there also till his very last days, this doctor. So that was the object of all this. So there's nothing unconscionable about the contract is what I'm submitting, my lord. And it is not their case. Your lordship saw the reply, my lord. It's not their case that is unconscionable. How can they argue, my lord, something which is not at all their case from day one? My learned friend showed, my lord, some portions of the cross-examination. I'm not going to trouble your lordships with that, my lord. And an overall conspectus, my lord, of the evidence that is placed on record, mainly documentary evidence, and evidence in the form of admissions made and depositions given in collateral proceedings where parties were there, and the timing. I'll say that and I'll conclude. The timing is very important. This notice, this OS, my lord, 1696 of 96 was filed by me on 7/3/96. The suit was filed by them, 5955, on 24/8/96. The legal notice to us, my lord, was issued on 18/3/96. After the filing of my suit to quit and deliver back possession. And if we juxtapose these with the legal notices, it becomes very clear that the minute I said, you please go forward and finish, they agreed, and he didn't come. Then I took the next step. That is when suddenly they wake up and issue these notices. So it's very clear that what they're seeking is just to somehow or the other prevent this from happening. Now, my lord, in the written statement filed in their suit, I specifically averred all these things, and there's no rejoinder to that. Now, they have a right to denial of whatever I say in the written statement. There's no such denial. So, my lord, their entire case, my lord, is not a tenable one, and it seems to be an attempt, my lord, in desperation to deny my clients. Now, the last submission my learned friend made was on equity, my lord. Should this agreement be enforced specifically? What will be the pros and cons? The property is worth so much more today. But if you go back and ask, my lord, what was 1 lakh worth then? In 1975, 1 lakh, my lord, they could have bought probably 1 acre of land in some other part of Bangalore. Because Malleshwaram then was a very sought after extension. Even newer extensions like Koramangala, Indiranagar, there nobody was willing to buy property there for even 10,000 rupees. Today it's, sky is the limit. So the thing is that if this transaction didn't take place, and this transaction took place not because of the close relationship, the close-knit family that was there. He was not married. He had no other commitments. He had his own business somewhere. He was not doing very well. And he decided to sell. After all this was happened and after receiving all the money, the cordiality was there at all points of time. Today, my lord, to say that don't enforce the contract, my lord, would be most unfair, is my very respectful submission, my lord. It would be placing premium on people, my lord, who have no regard for truth. They have no regard for anything. And they're just trying to find some reason or the other, my lord, to somehow try to sway the sympathy of the court. I know that won't happen, but the thing is, that is their argument today. Oh, the property value has gone up. My lord, the issue, my lord, on this amendment to the Special Relief Act 2018, the law has been sort of going up and down. The three-judge bench, my lord, took the view that it is not retrospective. A later judge that has been, that order has been recalled and the matter is again referred to a larger bench. In another case, my lord, another three-judge bench, my lord, has taken the view that though strictly whether that is retrospective, retroactive, we are not deciding, but all those principles of the amendment have to be borne in mind by the courts. That seems to be, my lord, what their lordships are saying. The 2021 17 SCC 705 Sugar Singh's case, the relevant para is 29. Para 29, it's the very last sheet of that compilation. Sugar Singh versus Hari Singh. For the aforesaid, even amendment to the Specific Relief Act of 63, by which section 10A has been inserted, though may not be applicable retrospectively, but can be a guide on the discretionary relief. Now the legislature has also thought it to insert section 10A, and now the specific performance is no longer discretionary relief. As such, the question whether the said provision would be applicable retrospectively or not, and or should be made applicable to all pending proceedings, including appeals, is kept open. However, at the same time, as observed herein above, the same can be a guide. Now, my lord, later, a three-judge bench, my lord, took a slightly different view. That was recalled. This is reported, my lord, in 2024. 2024 SCC Online 3214. This. My lord, if your lordships would see this 2024 SCC online 3214. In this judgment, my lord, at paragraph 52, that's the conclusion. Please go to para 32, my lord. The next issue is whether petitioners entitled to decree. This court held in 2008 that the amendment to section 10 of the Specific Relief Act does not apply retrospectively and decided the matter based on section 10 before amendment. This judgment has been recalled in the Sugar Singh's judgment, which I gave. There's a foot. This in this Siddham Shetty, the one that is 2024 SCC online, this recalls the earlier judgment in the same title. The reference to that your lordships will get, my lord, in the last page of Sugar Singh's case, where there's a footnote. The last page, at page 721 bottom, there's a footnote, my lord, editor. A 3-judge bench has since answered this question in Katta so and so, that the substituted section 10, as substituted by Act 10 of 18, is prospectively applicable, it being substantive and mandatory in nature. This is recalled. It's recalled. This editor's note is referring to the original judgment, which has been recalled in 2024 SCC. So the law now which stands, my lord, is the observation in Sugar Singh's case that this is a guide.
There is an error apparent to the face of the record in the factual finding recorded. The trial court recorded that the respondents did not produce records. Trial court expressly noted the DW stated that they produced certificates. However, during cross-examination, DW's 1 to 3 details they have not obtained and produced these.
So though there is no authoritative pronouncement of the Honorable Supreme Court today that the 2018 amendment can be applied entirely to agreements entered into prior to the date, the law as it now stands is that it can be applied as a guide.
This is on the facts. The recall is on the facts.
Yes, on the facts.
Here the facts.
Yes. But there were some observations in the judgment which authors interpreted as a pronouncement of the Supreme Court. That doesn't now arise because that entire judgment is recalled.
Section 10 before amendment in 2018 stated that the court can exercise its discretion to award specific performance of contract where there exists no standard for ascertaining actual damage caused by the non-performance, and B, when the act agreed to be done is such that compensation in money for non-performance would not afford adequate relief. Explanation provided that there is anything the court shall presume that the compensation in money is not adequate relief. There is nothing in the agreement to sell to rebut the statutory presumption. On an application of the facts to the principles of section 10 and 16, we are of the considered opinion that this is a fit case for this court to exercise its discretion to direct specific.
On the facts of the case, how the lordships had decided earlier, that was not assented to, and therefore they said we are recalling that order. But in the course of that order, in para 32, they made some observation that it could be retrospective. So to set it right, they said we are recalling, but of course on facts.
Is allowed in part directing to registrars scheduled property. On appeal, High Court held it was not a fictitious license discussion. Include the error. Without limitation. We recall the judgment dated 25th August 2022. The judgment of the High Court dated 23 April 2021 is restored. Review petitions are allowed.
I'm deeply obliged, madam. Great. We thank your lordship, Lord, for immense patience with which it has been heard, because very rarely we get a first appeal not being heard in this fashion. We are obliged.
The roster is so designed.
Supreme Court has said, my lord, in so many occasions that the first appeal is like a practical rehearing and the court should look at every aspect of it. But I think, my lord, because of the enormous pressure of time and the volume of work, the courts are finding it difficult. I remember in the past, first appeals, and it would be at least 1 week. That would be, especially partition suits and partnership suits. 4 or 5 days, my lord, was the normal number of time.
Courts to really understand all the aspects of the matter itself, it takes time.
That's true.
Just one argument may not do.
But since that section 230A may not be available, I can give a photocopy of that very short section. Because I found in my old library, I found it, even all the new books don't print them because it's deleted in 2001. I'll only give the photocopy of that section. Good. Good.
So, for the next please. Result. Sometime we continuous clearance. This kind of. Yes.
Number 38.
Just a moment, please. Just a moment.
Yeah, for the respondents, your lordship.
Just one moment, please. Just
Please
a
wait,
moment,
sir.
please. You're holding that. Yes.
Number 38. The SP Prakash. Sir, please unmute, sir.
This plaintiff's appeal. Plaintiff's appeal is a suit for partition. My lord,
2013, ma'am.
the difficulty is, my lord, the written statement and the plaint are in Kannada. And deposition is recorded in Kannada. My lord, I have no objection if lordship says,
No, no, in a first appeal, we cannot do that. In a first appeal, the court must know what the pleadings are and what the, probably in a writ petition or a writ appeal, probably we can just look at what is relevant, not in a first appeal. It is a reappreciation, the continuation of the proceedings.
I need to file my lord translation.
Request of that same. Translated copies. Like documents.
Yes.
Yes.
39.
For what? 38, what has happened?
Sorry,
38, your lordship.
we've given 2 weeks time for a translation of the relevant documents. We are told that the pleadings and the evidences.
Yes, Kannada, your lordship. 2 weeks time to, for Kannada and English translation.
Yes.
Yes.
But for the
39.
appellants, appellants are the plaintiffs' lords. The suit is for partition and separate possession of their 3/5 share. Of course, lords,
Is a full hearing required?
please, lords,
We cannot start now.
please,
We have almost 3 RFAs
please.
which we've taken. Let's,
Lord, now, Lord, whether I should continue?
After 2 weeks.
Lord, now, Lord, I am, Lord, because parties are insisting, Lord, there is some further alienations. Earlier, Lord, and I have filed an application for injunction that was disposed, Lord, rejected on the ground that a matter is ripen for hearing in the earlier, Lords. Now, Lords, hardly there are some sites are available.
You can file
For
application
this-
if you want.
file a fresh application, we'll hear
Please.
that on the merits.
Please,
They are
please,
served
please,
and not
Serve
appeared.
copy and
please. Lord, now, Lord, respondents are,
they're not
remained absent. Even before the trial court, respondents are, Lord,
file fresh, then they make up.
I can finish it, Lord, half an hour, Lord, I can, but it is,
Writing is difficult now.
please, please, please.
Of volumes of that.
Only section 6(4)(5) of the Hindu Succession Act, Lords, there is no partition as such, Lord. On the other hand, the trial court assumed that there must be a partition. Therefore, otherwise, Lords, the RTC would not have been entered into. That is only the crux of the matter. Please, any date, my lords.
You could file an IA,
Please, please, I
that can be considered.
oblige.
The request of learn funds for that being list after week after next.
Oblige.
Number 40, Sri Sharavana S.
I appear in 40.1, your lordship.
Yes. What is this about?
It's a land acquisition matter. The learned single judge has dismissed only on the ground of delay and laches. In spite of the any number of decision of the Supreme Court, particularly when the land is acquired for society, all this will not arise. That is the number of decision, your lordship.
Preliminary notification of the year 1984.
1990.
Final notification 86.
Very same notification was set aside.
In fact, acquisition of lands in that very village has been set aside by the Supreme Court, your lord, Chandrapa's case. And Supreme Court laid down a law, there's a question of reciprocata will not even arise like.
Which society?
Vayali Kaval Society, my lord. And in one of the Supreme Court cases, Supreme Court has characterized the society as a bogus society.
Very same notification.
Your lordship may disconnect that from serial number 40. Then
What is serial number 40?
serial number 40, I don't know, they have got connected to this because we had an interim order of stay in this case. They got connected. Therefore, your lordship may disconnect it and post our 40.1 and 40.2. Both are the same, your lordship.
40.1 and 2 are with regard to
Yes, you are.
this Nagavara village,
Yes.
2011.
2011. 11. What is one? What is 40? It is also same notification, 1984-85.
Yes, your lordship, same notification as far as 40.1 and 40.2 are concerned, the same notification.
40 also,
40, I don't.
also appears to be same notification.
In that matter, they have not questioned any notification. Regard validity of the notification was not questioned, my lord.
Sorry?
Validity of the notification was not subject matter in that petition, my lord. That is belong to.
It's Khata,
Please, my lord.
BBMP.
HPC layout,
Regard to LB,
cancellation of layout plan by preferred petition. Of mandamus against government and BBMP not to demolish buildings without following due process. Dispute on Maker. Agora village was probably.
Very same notification.
Chandrappa.
ಚಂದ್ರಪ್ಪ ಎಕರೆಗೆ ಹೇಳಿ ಅದನ್ನ ಹೇಳ್ತಿದ್ದಾರೆ ಚಂದ್ರಪ್ಪ ನೋಡ್ತಿದ್ದಾರೆ.
It's very same grounds. Very same grounds. They say it is necessary to submit that reference to same acquisition proceedings apex court while passing orders in SLP 14/7/99. Delay cannot be a reason to dismiss writ petition when society itself was held to be bogus society. Let's see what the prayer is, the writ petition. Not to demolish, quash the copy of order dated 16/4/2010, annexure N. Or in the alternative, to quash the final notification.
Yes, sir.
Same prayer.
Lord, ours is a 2011 matter and this is 2021. Your lordship may hear our matter. If we get a relief, they may also get a relief.
Probably, they're just saying that it's not completely different
Yes.
and the tagging may not be, it appears, probably there is delay, but it appears that the pleadings are almost identical.
LB BBMP ಅದು.
That is a,
Annexure N, just a moment.
LA
Let's see what-
BBMP must be the party.
Let us see what annexure N in the other one is. It- Cancellation of possession certificate issue. Yes, we'll hear you.
The lordship may fix a short date. They have filed all the citation, everything in a compilation are given.
No, the IA has been allowed? They've been allowed.
Which, in which matter? 40 point?
40.2.
40 IA number? LRs of? You yourself filed application. Can be allowed, sir?
My lord, one submission, my lord. In this 40.2, I am appearing, my lord. My name has been deleted. My learned friend name is shown. R.S. Segre, my name may be.
Please.
For appellant,
Yes, ma'am.
but application you tell.
Yes, there is no problem. I will
no
not be-
problem.
My name may be.
Regularization, so and so submits that he has no objection to allow IA 1, 2, 3 of. Yeah, where?
You have 2025.
Except in the
25.
cost shown, delay of so and so days, filing an application is condoned, abatement is set aside. Legal heirs of the respondent number 6 are permitted to be, permitted to come on record. Accordingly, I is allowed. Appellant shall amend the cost title.
Amended cast title I will find.
Ah,
Amended cast.
yes. The registry is directed to reflect the name of Sri
R.S. Segre.
R.S. Segre.
R.S. Hegde. is a counsel for the appellant. ಇಲ್ಲಿ ಯಾರು ನೀವು? Three, also registry is directed to show the name of Nayak. ಬರ್ಕೊಳ್ಳಿ. As a counsel for respondent number R 6A to E in the cause.
Serial number 40 may be put below ours, your lordship, because.
That's it.
Okay.
No, ours is a 2011 matter, that's why. Because if matter is there, where 2021, it will be not listed, your lord, that's our anxiety.
Writ appeal 16808 of 2011 as a
As a leading case.
appeal, and other matters will be connected with the same. Please list.
Short date. In short date, your lord.
Week after next.
10th March.
10th March.
That will be too long, your lord. 25th or 26th of this month.
ಇದ್ರ ಕೊಡಿ ಹೋಗ್ಲಿ ಇದ್ರ ಆಗತ್ತೆ ಇಲ್ಲ ಅದ್ರಿಲ್ಲ ಇಲ್ವಾ? Dates are full. 10th,
First week of March there is,
5th March.
5th.
5th March. Forty-one. Yes, Vijay Kumar.
Appeal not admitted. What is this KLR RR? Yes, what is this about? Oh, that is the matter.
this.
Hmm. That has already been done in full contention. The evidence from the disputing facts and
Why?
that the appellant be here.
Why infructuous?
After
After
the-
remand, it is order is passed.
That is what he says.
Hmm.
And after remand, an order is passed. The appellant's contention is that the Tahsildar has not heard it, the assistant commissioner has passed orders, and that is without hearing is the contention.
This is SC not, right?
Yes, yes. Tahsildar has not passed an order. Their contention is that the assistant commissioner has passed an order.
Just to whether there was. Previous visibility petition.
Where is the order passed by the Tahsildar? As. Remember, right, it was the AC was back here. He was reminded to the Tahsildar. AC passes.
The commissioner also stated that in the observation.
The same as been challenged before the assistant commissioner. It's pending.
And then.
There is a. Just a moment. There is a. Dispute with regard to the. Even so, there has been an entry. Hindu and priest. Entry has been found to be bad in law for whatever reason. Now, that entry is, it has been restored to the, handed to the Tahsildar to decide. And the entry, which is found to be bad in law, whereas to be restored. That is the only one.
But after restoration, another order is passed by the Tahsildar after remand. And Tahsildar order is challenged by the party before the assistant commissioner.
Right, all that is true. Their only contention is that after finding that.
Restoration. You
Yes.
can just see that
absolutely.
it is only after the next round of proceedings.
Absolutely.
Now what Tahsildar has done?
Their contention is that there is also holding the same thing only without.
In favor of the appellant. And clear judgment rejected after the full range of hearing by the respondent as well as the appellant.
What happened to the civil suit?
It's pending.
May.
This is pending in the certification. It's on the stage.
Let him come now.
Let him come, without him.
Maybe taken up. The appellate stage makes it sufficient.
Huh?
Yeah.
Why final hearing ಬಂದಿರೋದು ನಟರಾಜ್? ನಟರಾಜ್, why it is in final hearing? Final hearing ಯಾಕೆ?
This is all there is to it.
Why it is final hearing? It is in final hearing. Why matter is? ಅವರೇ final hearing ಹಾಕ್ತಾರ. Not admitted ಅನ್ನೋದು ಅವರೇ final hearing list ಕೊಡೋದ. Registry, there is no representation for the appellant. List on so and so for admission.
17th.
Next date.
20th.
Admitted.
ಯಾರಿಗೆ ಅಂತಾನೆ ಹೇಳಿಲ್ಲ. ಅದೇ not admitted. Sign ಮಾಡ್ಸ್ಬೇಕು. ಇನ್ನೂ delivery ಮಾಡ್ಬೇಕು. ಹಾ, ಇವತ್ತು ಕೆಲಸ ಮಾಡಿ. ಯಾರಿಗೆ ಅಂತ ಕೇಳ್ಬೇಕು.
20th March.
ಫೋನ್ ಮಾಡ್ಬಿಟ್ಟು ಹೋದ ತಕ್ಷಣ ಕೇಳ್ಬಿಡ್ತಾರೆ ನಮಗೆ. ಅದು 37 ಆಗನಂದ 37 ಈಗಲೇ ಹೇಳ್ತೀನಿ. ಬಟ್ ಸಿಗ್ನೇಚರ್ ಮಾಡಿಲ್ಲ. ಟೈಪ್ ಆರ್ಟಿಫಿಟ್ ಕಳಿಸ್ತೀನಿ. ಇದು ಯಾರಿಗೆ ಅಂತ ಹೇಳ್ಬೋದು. ಬೆಳಿಗ್ಗೆ ನಮ್ಮ ಸಾಹೇಬ್ರಿಗಾಗಿತ್ತು, ಮೋಸ್ಟ್ಲಿ ಮೇಡಮ್ಗೆ ಅನ್ಸುತ್ತೆ. ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡಿ.
39 2 weeks ಅಲ್ಲ?
ಡೇಟ್ ಗೊತ್ತಿಲ್ಲ.
ಎರಡು ಇದು ಇನ್ಸ್ಟ್ರಕ್ಟರ್ 2 weeks ಅಂದ್ರೆ 38 ಅನ್ನು 2 weeks ಟೈಮ್.
4th 5th ಆಗ್ಬಿಡಿ. 4th 38
2 weeks ಟೈಮ್ ಗ್ರಾಂಟೆಡ್. ಇರ್ಲಿ ಬಿಡಿ, ಡೇಟ್ ಬೇಡ.
ಟ್ರಾನ್ಸ್ಫರ್ ಡೇಟ್ ಕಾಪಿಗ.
2 weeks ಟೈಮ್ ಗ್ರಾಂಟೆಡ್.
ಆಯ್ತು, ಅವ್ರು ಮಾಡಿದ್ಮೇಲೆ 39 ಮಾತ್ರ 4th March ಹಾಕಿ. ಆಶಾ 39 4th March. 45th March. ಕೈಯಲ್ಲೇ ಬರೀರಿ ಬೇಗ. ರಿಪೀಟ್ ಯಾವುದು ಇಲ್ಲ. ಎಜುಕೇಶನ್ ಬರ್ಬೇಡ್ವಾ? ಮಾಡ್ಸೋಣ ಅನ್ನೋಷ್ಟಕ್ಕೆ ಪಟ್ಕಂತ ಅದು ಸೈನ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ಕೇಳೋಣ ಅನ್ಕೊಂಡೆ. ತಿರುಗಿ ನೋಡೋ ಅಷ್ಟಕ್ಕೆ ಎದ್ಬಿಟ್ರಿ. ಇನ್ನು ಅವಾಗ ಏನು ಹೋಲ್ಡ್ ಮಾಡೋದು ಚೆನ್ನಾಗಿದೆ. ಸಪ್ರೇಟ್ ಮಾಡ್ತಾರೆ. ಯಾರ ಕಟ್ ಮಾಡಿದೆ
ಸರ್, ಇಬ್ಬರದು ನೋಟ್ಸ್ ಇದೆ.
2021 ಬಂದಿದೆಯಾ? ಎರಡು ಬಂದಿದೆಯಾ? ಅದೊಂದು ಹಾಕಿಬಿಟ್ಟು ಫೈನಲ್ ಮಾಡಬೇಡ. ವಿಷಯ ಬರುತ್ತೆ. ಕೆಳಗಡೆನೆ ಲಿಸ್ಟ್ ಆಫ್ ಅಥಾರಿಟೀಸ್ ಇಟ್ಬಿಡಿ.
ಸರ್ ಎಲ್ಲ ಹಂಗೆ ಬರ್ತಿದ್ದೀನಿ ಸರ್. ಸಿನಾಪ್ಸಿಸ್, ನೋಟ್ ಆಫ್ ಬೋತ್. ಅದು ನನ್ನ ಅಡ್ರೆಸ್ ಎಲ್ಲ ಹೇಳೋದು ಇರ್ತದೆ. citation
ಪೇಪರ್ ಬುಕ್ಸ್ ಪ್ಲಸ್ TCR. ಕೊಡ್ತಂಗ ಟೆಂಡರ್ಗಳು. ಹೇಳಿ ಯಾರಿಗೆ ವಿಚಾರಣೆ? ಹೌದಾ, ಕೇಳಕ್ ಹೋಗಿದ್ದಾರಾ? ಆಯ್ತು, ಬಂದ್ಮೇಲೆ